Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican, please, verbal Latino.
Scratch all that. Oh, that was terrible. I apologize.
You know it's a good day when my camera works first thing, right? But my TV looks like it's almost black, like I can barely see the picture. Okay, not calibrated, not dark, standard computer. Oh, let's try that computer. Crank that brightness up. Okay, now I can see. That's a little too much. There we go. All right, welcome to the Court of Public Opinion. I am the Recovery Addict. Good to have you here. Welcome. Get rid of that so I can see what's happening. Let's see, I fit in my box today. Everything is good. Happy Monday to you. Hope you had a fantastic weekend. I sure did. Let's see here. We've got put that there, and where am I? There I am. Give it a minute. We'll be here. All right, we're getting everything in order as we're getting ready to start today with the taking care of Maya trial. It's going to be a spicy week in this trial. Let me just say it's getting very, very interesting. So we'll need Kim R. Kim, we'll need you to do your thing this week. You are first in chat again.
Because he's the guy.
Well, she's the woman, I think is the way it goes. But Kim, you were first in chat, so that means you win the internet once again. Why is my camera like? That's a little better. Now you can see my screen and my window and everything else. Let's see. I know I'm missing something. I just can't remember what it was. Congratulations, Kim. You did win the internet. You get to being first in chat has its prize, punishment, privilege, whatever you want to call. You have to take care of everything IP related. Let's see. That would be your responsibility and your responsibility solely until someone else wins the internet next time we go live, which will be about probably after lunch. So thank you very much, Kim. I'm excited about that because I don't have to do it, quite frankly. One less thing I have to worry about this morning. I've got enough to worry about right now. I really do. I've got my hands full. All right, let's see. There is a ton of stuff going on right now. Let me just see first. Let's do probably birthdays. Let's see. We've got Queen Olive. Queen Olive has a happy birthday today, right? Is there anyone else who has a birthday today? Let's scroll down to the bottom and see if somebody will post it for me. Let's see. I'm looking. Might just be Queen Olive. Hi from the UK, Kieran. Welcome. Or Kieran. I apologize. I said Kieran. I think it's Kieran. Let's see. I don't see any of the birthdays here this morning. Let's see. Mandy May says, Recovery Addict, can you please share the missing child poster, Amber Alert, New York. Her name is Charlotte Sina. This is the 9-year-old girl that was missing, went on a little bike ride just around the little campground loop that they were on, and they found her bike, but she's gone, right? This is awful. Yes, I don't have the poster ready to share, but for anyone in the area, please pull up that poster. Just take a look at that face. Make sure you are on the lookout for that little girl. If you see anything suspicious, call someone, say something. Let's see. Last call for birthdays. We don't have much time because court's going to start here in just a minute. Let's see. I think it starts very, very, very soon. In like 8 minutes. All right. Let's see. I think I'm blocked. I lost my courthouse. Teresa, you're not blocked, but your courthouse did disappear. It's missing. We need to find it. No, October will be big for birthdays. Just not today, apparently. Just Queen Olive. Queen Olive, you're going to get a solo. Well, it's not a solo, but you'll be the only person we sing to, apparently. Because there's nobody else who's fessing up to the fact that today's their birthday. So Queen Olive is going to get a rare, specialized, what do you call it, personalized, and I don't know, it's a solo for her. But everyone sing. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Queen Olive. Happy birthday to you. There you go. Happy birthday, Queen Olive. I hope you have a fantastic birthday. If we can make it any better by bringing you court, guess what? Boom, we'll do that. We'll do that. We've got it right there. It's ready to go live in just a minute. Hope you have a great day. I realize there are a million places you can go and celebrate your birthday, and places where people would even give you free stuff, like Denny's. There are other restaurants as well, but that's my go-to because it's breakfast time, right? Glad you could be here. Thank you. It's our privilege, our honor, our pleasure to be here and share your special day with you. Have a good one. Thank you so much. Let's see. Hope you appreciated my harmonies. Oh, they sounded beautiful. They sounded beautiful. It was a personalized serenade. Oh, personalized is when we change the name. What is it called when it's just to that person? Is that personalized, or is there another word for that? All right. I think that's all. I think we're gonna get ready for court here, but not like that. There we go. Let's bring this up and that up. It's always breakfast time somewhere. Breakfast should always be on the menu. Those restaurants that serve breakfast 24 hours a day, they get it right. They really do. Elta Fez says the birthday sing-along is one of my daily highlights because it keeps the positive vibes. That is wonderful. Thank you very much for that. Thanks for sharing. Thanks for singing along, honestly. KT, thank you for being such a warm, accepting, and compassionate group. We definitely have some of the best people in the world out here in this community, and thank you so much for coming together with here. Shout out to JB this morning, way up in the frozen tundra of Canada, 150 miles north of Toronto. Hope you're doing well, JB. Haven't talked in a while. We'll have to talk again. See how things are going. Individualized. Individualized is the word, I think Crystal says. We're going to go with individualized. Kim R., birthday in 14 days. 14 days. That's 2 weeks. Guys, I did the math. Exclusive. There it is. Eileen, exclusive is the word we're looking for. It is exclusively your birthday song. Oh, Creative B is here. Hello, Debbie. How are you doing? Welcome. Good to have you here as well. We need to get our... We need to get our objection counter up. Holy moly. Would you guys check this out? I don't remember. Is this number right? Let's see. Preview. No. Super source. Okay, we've got DSK2. Is that it? Oh, that's the wrong one. Well, we're getting there. We're slowly getting there. Super source. Where are our objections? I think it's this one. Objections. Where's my camera? Okay, here we go. Here we go. We're getting there, guys. We're getting there. Hold tight. 6. Okay, now camera 2 is going to be 2. And cut. Boom. There we are. 233 objections. That took a long time to get here. Oh, man. It's definitely a Monday for sure.
Address subject matter jurisdiction.
Probably should. Let's see. Amanda Davis, 13th Addict, thanks for all you do and a great chat. Thank you very much, Amanda Davis. Great to have you here. Love seeing that courthouse changed by your name. Appreciate your continued support. it's going to be a fun week. Flower delivery for Judge Boyd today. We have to watch for that. It should be a lot of purple and a purple vase if they get it right. Should be a nice display for her. So we'll keep an eye. If somebody can keep an eye on her courtroom as well, that would be wonderful. See if that delivers properly. It should get there before noon. That was their morning delivery, means before noon. So I was thinking morning delivery would be like first thing in the morning, but no. So it's Flower Day today for Judge Boyd. CrimeCon tickets go on sale today, says KS. That's for what is it, Nashville? Where is that? It's in Tennessee, or I forget where it's at this next year. Tammy L says, I quit smoking 9 years ago. Big accomplishment for myself. Tammy, that is awesome. 9 years is huge. That is huge. That's inspirational to so many people. Thank you for sharing that. I appreciate that. It is an Admiralty flag for sure. We're in Admiralty Court. So, yes. Let's see. Thank you. Everyone feels amazing to be set free, says Kieran. Hope she gets them, loves them. I hope she does as well.
For the trees.
I especially like the fact that we included her staff on the note, because she recently spoke about how incredible her staff is and how they make everything happen and how wonderful they are. So I'm glad we got to recognize them as well. Megan says, not sure how I feel about CrimeCon. I was the same. But after watching a few people I know attend and share the experience they had there, I'm leaning more towards it. I'm not sure how I feel about paying what they want me to pay for a ticket. that does not make me feel good at all. But we'll see. Let's see. Mom to an Angel, good morning. Good to have you here. 2 months as well. Appreciate that anniversary message. Let's see. There's something else that was on the tip of my tongue. Oh, let's see. Oh, we're debating right now the podcast on Friday night. I'm not sure if we're gonna take a week off. There are two options. Either we're going to take a week off, or I'm going to convince Mrs. R.A. to join me and co-host the podcast. So if Mrs. R.A. co-hosts the podcast, we'll need some questions that you guys want answered. I'm wondering if one of our great mods over on the Facebook channel might be able to put a little engagement post up there asking what questions you'd like to hear Mrs. R.A. answer about whatever. And that might be, once she sees some of the questions, she might be more inclined to participate for the podcast. She would be on camera, finally, at last. Denise Feldman Ursuline says, best 9 months ever. Thank you, Scott, for all that you do for us. The mods aren't bad either. I can't imagine being anywhere else. The mods aren't bad. Love them. Lego My Briefs says, I'm not going unless you're going, says Lego My Briefs. I'm looking at it. Actually reached out to them a little bit, so we'll see. We'll see what happens. I think the only thing that I would be disappointed about on this, if we did Mrs. R.A. on the podcast, is that Thomas couldn't interview her, because Thomas is such a great interviewer and I am not. He would do such a better job than me on this one. So we'll see. Anyway, we'll see if we can get a Facebook a post up where we can have a couple questions posted where we can see what you guys want to know. All right, I've got one more thing to do. Here we go.
Please be seated.
Court's beginning right now, so shh, everyone sit down.
Someone's got an open mic.
It's me, Your Honor. I apologize. Have you tried turning it off and on again?
Well, let me see if I can find it.
Bring the jury.
Password PASSWORD 123. Enter. Okay, you're logged into the system now. It's a very secure system.
Testing 1, 2, 3.
It's working, Your Honor. I can hear you loud and clear.
Does any of the lawyers have an open mic?
Do you want me to turn it off?
Madam Court Reporter, is it yours?
I can turn mine down.
2 microphones that I have used since day one, and it's not done this up to this point.
Is Jack at the front row? Maya's not on the front row. Maya's not there right now. I don't see her. She might be here later, but
We'll get to the bottom of it.
Oh, we will. We're going to find out exactly what's going on. Between His Honor and myself, we're going to resolve this.
Testing. Testing 1, 2, 3.
Still hear it.
It
Still
almost
hear it.
seems like it's coming from right here.
It
Yeah.
does. And I have my 2 mics sitting there that they've been.
And now all the mics are off, which is
5,
worse.
3, 2, 1. Let's take appearances.
Howard Hunter, Your Honor, on behalf of All Children's Hospital with Ethan Shapiro, Patrick Crowells, and David Hughes. And our corporate representative today is Dr. Michelle Smith at my extreme left.
From a preview, while we're waiting for IT to come deal with the echo, there seems to be a lot of things we've got to deal with this morning.
Lots of things.
We've got an echo issue that's coming from over here.
I sent my IT guy down to
Our laptop is for that surface.
Just going to log in real quick.
1, 2, 3. You fixed it. No.
Nope. Everyone yell echo. Echo, echo, echo. See if you can help find it. It's a microphone issue. It's not a speaker issue.
Testing 1, 2, 3. 1, 2, 3. Test 1, 2, 3.
I think some volume was turned down, but the microphone, I still hear it a little bit.
Testing 1, 2, 3. Testing 1, 2, 3.
Can you push that microphone down a little bit? Okay, thank you.
Is the
Much better.
the plaintiff's lawyer's tie crooked
There
this
seems
morning?
to be a number of issues we need to deal with this morning. Looks like there's a lot of exhibit issues that we have to deal with. I'm ready to discuss my thoughts on the jury instructions relative to suicide issue. I'd kind of like to get that also done, but that's probably going to take 10 minutes or so, given my thoughts. I did receive both memos on the issue of the delayed disclosure. I don't think we have time to deal with that this morning.
It's going to be tomorrow.
Late this afternoon, if not,
Ooh.
we'll deal with that tomorrow.
The judge.
We can have him here though at a break or later. I didn't realize we were going to argue it this morning.
It's not more of an argument, it's more of a pronouncement. And we can probably have, I'm actually going to be asking when I make my thoughts, I'm going to ask the court reporter to actually transcribe that portion of it and send me a copy of it. So he'll have that. And then I saw there was also a motion to ask for a special instruction relative to the Facebook message from Friday, and then of course whatever you all need. So it's very ambitious. Has there been further movement on the exhibit issue from this exhibit list?
Your Honor, we have.
Has there been further movement on it, yes or no?
Barely. Most of these two are.
It's going to be a bit rough week.
803 or 804, and that's.
So the answer is no.
The answer is no.
Okay, let's not. We don't have time this morning for long-winded answers. I can go ahead and receive those that were stipulated to. Is that correct?
Yes, sir.
The court receives the totality of Exhibit 2044, 2353, 2354, 2355, 2356, 2362, 2419, 2420, 2421, 2425, 2426, 2428, 2435. Now let's move on to what you need to, Mr. Anderson, relative to these exhibits.
Yes, Judge. So we can either take up all of the exhibits for today, which would include those, so the court's aware. We have first Yarek Silberic, the detective on the scene.
Are you intending to use all of these exhibits today?
That's the idea. I'd like to get as many of them as we could.
That means he has to do all this work this morning.
Okay.
This is a lot of work.
Well, let's start dealing with them.
And it's on this exhibit list beginning with 2018.
However you want to do it, it's your case.
I'll tell you what. Do you have the list for Yarek Silberic? A short list?
No. I have the full list apparently for today.
If I may sit down, Judge, I think I can transpose real quick and tell you. Actually, just let me tell you the ones we've got to worry about today.
Just start with one. Let's
Yes, sir. 2031, photographs from the scene of Beata Kowalski's death. Actually, we're not going to use that. We're going to use 2031A, which is photographs from the scene of Beata Kowalski's death, blurred. And then we would like to put in later 2031 unblurred, but for today in the public realm, we would like to use the blurred face.
Okay. Why are you going to put in, is it the same photo, just blurred and unblurred?
It's the exact same photo, it's just a face.
Why are we putting in two different versions of the same thing?
Public dispersal of the image of Beata Kowalski and with her being able to see her
Look at the lady in
face
back shaking her head.
going out in the media. We would prefer not to have that. But for the jury, obviously the original is the better choice. I am open to suggestions.
Judge should rule this picture shouldn't be shown.
Ms. Crowells.
Thank you, Judge. We object to all of the photographs. We don't think any of them are necessary for the purposes of the issues in this case. There's no dispute that she committed suicide. If the court is planning on putting in any of the photos, we don't think that the last photo that shows the frontal view and shows her face blurred or unblurred is necessary. It doesn't add anything. There's no additional information for this jury to make its decision that these photographs add at all. And we especially object to the one that shows her face. There's no issue that these address for the jury.
Well, here's my view on the blurred versus unblurred. If we are showing something to the jury, then I feel the public has the right to see what the jury sees. That's part of the genius of our system. So,
make a choice, right?
Well, if you wish to put in the unblurred, then that's what is going to be shown here in the courtroom. And then if the media wishes to blur the image, that's the media's choice. But we're going to have the...
Wow.
We'll go with 2031, the unblurred. Hopefully the media will be respectful and
2031.
And blur out
I hope
her
they
face
give us some warning because I'm going to cut away from that.
How many photos are we talking about in this series?
There are, I believe, simply, well, let's see. Photo of the house, photo of the dryer. Don't we have one up from the back?
There's 26 photos in 2031.
All right. Then there is, for right now, there is, let's just move to the next one, which is 2031-003, photo of the front of the house with police tape across the driveway, document date, time.
I'm sorry, Judge. I don't know where Mr. Anderson's talking.
I'm asking pointed questions. Let's not have lengthy answers. I just need a specific answer. How many photos are in 2031?
4 we intend to put in.
Well, Judge, I don't know which 4 those are because they just gave them all.
Okay. How many are in the series? Just tell me that.
26. 26 in the series.
Okay, we're not putting 26 photos in of the same issue.
Yes, I understand.
Now, on Ms. Crowell's point about not putting any in, I disagree with that. I do think There was evidence, or is going to be evidence, that Mr. Kowalski viewed the scene, and I feel like that's going to be relevant to the issues in this case. So you're going to get some, but you're not getting 26.
Yes, Your Honor. If I'll explain, Ms. Perry is ill this morning, and I had 3 others, and I will identify them quickly while we
Kelly
go
is
through the
ill.
rest. But I'll just tell you very quickly.
Kelly Perry.
Within 2301, one is the same photo from behind. Another one is of her wrist, and another one is from
Can you just tell us the 2031, what numbers? That's, we've wasted about 7 minutes trying to get to this specific point.
019.
Go ahead.
You want 019.
Keep going. Keep going.
There's a total of 26.
Yes, I know. That one.
The judge is losing it here.
021.
I didn't hear that. I'm sorry.
021.
Okay. All right, actually go back. That one.
023.
Okay, go back. That one.
024.
That's 4.
That's 4.
Do you want the one with the police tape though?
Well, the police tape's a separate one.
Okay.
Go farther up.
This is the first one.
Keep going, just go fast.
That's 4. And now they have another one.
Go back one. Another one. All right. No, keep going.
The judge is going nuts here.
We do not have time for you not to be prepared, Mr. Anderson.
And that is
011.
011. So one more, Judge.
That's 5.
Okay, so there's 5 photos. Defense, have you looked at those 5 photos?
I'm looking at them real quickly, Judge.
Now, for the members of the public, let me just, when are these photos coming?
Please
this
warn
morning?
us.
Okay.
Well, with Detective Sopheric. Which one?
I anticipate and expect that everyone in the courtroom, including the gallery, just give you a heads up. Some of these photos are pretty gruesome, and I expect everybody not to react when they are shown. I think we are all adults here and understand that, this is coming. If you don't think you cannot react, or if you're going to react, or you think you're going to react, I'm going to invite you to leave when that happens, because I do not want a spectacle in the courtroom when these photos are shown.
Okay, so I can tell you right now that there's a good chance that some of these photos will be shown on one of the major streams, even if just briefly. So just be aware. I'm going to do my best to not show them. If you want to see them, you could go back in time and maybe watch them.
Watch them just regular relevance.
I'm sorry.
Anything other than regular relevance on those 5 photos?
On this one.
On 0, I'm sorry, are we still in 2031, Judge?
2031.
Yes. So we would object to the 011 photograph.
And what's the basis for that one?
Hearsay. It has
Photograph has hearsay?
not something that Mr. Kowalski, I don't think, viewed.
I'm going to need to.
That's a week.
So either someone can just hand me the photo, or
Here, I flagged the ones, Judge, that.
Okay. So this might be a note of some sort.
I'm going to overrule as to 011.
Okay. All right.
Anything with the other 4?
No further objection other than stated.
Okay, the court's going to admit over the defense objection 2031-011, 011, 019, 021, 023, and 024. What's next?
The next is, I don't know if this is encompassing with it. You just ruled on 011, Judge. Is that right? Yes, I see. Okay. Police report, it's 2032.
2032. You're putting in a law enforcement report?
Yes.
Yes, Your Honor. It's 8038.
Yes.
Law enforcement reports generally don't come in. So explain to me why you're trying to put in a law enforcement report.
You know, now that the court mentions it, I think what we'll do is just use a refresh recollection on that.
Okay.
What's next?
And then
this is awful.
232-12 to 13. Those are the suicide notes.
Wait a second.
I'm sorry.
What number?
The suicide
you're
notes.
You're reading wrong numbers.
232-12
You're missing a number someplace.
and 13.
Judge, he's talking about within 2032.
Within 2032.
Yes.
If I could help. So
Within
I'm not sure.
2032, what are you trying to put in now?
Suicide notes.
Is there a number on those?
There's going to be objections here.
2032-12 and 13.
Thank you. Yeah. 1 second.
They're trying to find the best objection for these.
Those aren't these actual suicide notes. Those are the transcriptions of them that appear in the police report or in the autopsy. I'm a little confused.
Those are the actual notes.
Those are the actual notes?
The actual notes.
Okay.
All right, Judge. No objection.
Okay, so
wow.
Mr. Anderson, you're representing that 012 and 013 of Exhibit 2032.
First, they objected,
is the
saying they were not the actual
notes.
Yes, there were two. There was one that was transcribed within the police report, and there was a second one that was typed out by Beata Kowalski and then printed out. We have the printed out pages.
So, no objection from the defense?
Is that correct?
I'm surprised there's no objection here.
Well, 012 and 013.
I'm sorry. No,
Judge.
It's suicide 1 is 12 and 13. 232, 12 to 13 is suicide note 1. 232, 14, 15, suicide 2.
You have 4 digits, not 3 digits for your exhibits. Okay. And you keep...
Right.
He's doing his own numbering systems.
2032.
2032, 0012, and 0013. Original suicide note 1. 2032 -0014 and 0015. Second suicide note.
Judge, we're going to object.
On what basis?
Hearsay.
That's a good objection there, but this might go to state of mind.
8043. Tell me what you're
Statement
saying.
of dying declaration. Statement under impending death.
Courts, and we agree 012, 013, 014, and 015 are the correct pages.
Yes.
Let go of the microphone.
The court's can overrule the defense objection. I will receive into evidence 2032 pages 012, 013, 014, 015. What's next?
2034. For the record, Sarasota County Sheriff's records, Beata Kowalski death.
So you're trying to put in the law enforcement report again?
No, I believe this is something different.
This is a death record.
Judge, it contains the law enforcement report. It also contains the autopsy report.
No, Judge, there's only one part of it, and it's actually down at 2034-0019, which is a list of the medications found by the detective on the scene.
Just out of curiosity, did you tell them that you were only going to use 0019 out of 2034?
I don't recall exactly what the conversations were because, to tell you the truth, Judge, we never got that far in our discussions.
Judge, there was no discussion about this. They gave us the list yesterday, part of it at noon, part of it at 6, and one at 9 o'clock at night. They said, this is our list. What you're seeing here is they created this list. I just added my objections to the side. So this is what they sent us. They're putting in this exhibit, 2034.
And this is precisely what I'm trying to avoid, Mr. Anderson. I need you, and I need your team, to be specific with the exhibits that you're going to use. If you are going to only use certain pages, identify those certain pages. We have spent probably 15 minutes this morning of time we don't have while you're trying to figure out the specific page numbers. That is not my time that we should be dealing with.
I understand, Your Honor.
So, and I can't have this rolling, 12, 6, 9 p.m., especially on a weekend. So I think we need to get back to, you've got to tell them by the end of lunch on the day before, the business day before. So that means today at the end of lunch, you need to tell them what your exhibits are for tomorrow.
That would be extremely difficult considering the preparations for the next witness and with the witnesses for the next day, in this instance, simply because there are two doctors, Dr. Kirkpatrick and Dr. Hanna. And that will require at least an hour's worth of review from me to separate out. The reason we're having these problems is I have a sick paralegal, and Kelly Perry knew all about these, and so we jumped into it relatively late when we knew she finally said, I can't go.
Kelly Perry.
So all of this was
She
worked
makes this
out.
whole show
I point
happen.
out the defense has had all of these for at least a year and a half. And so what we'll do, though...
Again, I've been on you to narrow the list and to be specific, and you haven't done that. And if it looks like I'm starting to lose patience, that's because I have lost my patience on this issue.
I understand.
I don't have time, and it's unfair for our jury. They're the ones that are going to bear the brunt of you're not being prepared.
Yes, Your Honor.
If he keeps doing this, the judge will rule against him on
before the jury comes in 6 minutes.
Exhibits.
I would suggest that we do Debbie Hanson's exhibits, which are...
I have no idea who Debbie Hanson's exhibits are because I don't have that on my list. Just give me a number.
1001-2030.
I missed the first 4 digits. Tell me again.
1001. That's already in evidence.
That's in evidence,
All
Judge.
right. And so is 32?
Yes.
And is 2165A71?
No, that is not in evidence. You need to discuss it.
All right. This is 2165A-71. Can we put it up, please? What exhibit? 2165A-71. Just a moment.
This is so bad.
Now, obviously, Judge, we're going to highlight the relevant portion of this. This is the accessing records for Maya Kowalski's Johns Hopkins record on October 8th, 2016.
When you say the access log, this is of
What?
the medical records?
You guys
Yes,
see
Your
this?
And this is who was actually viewing the medical records?
On the 8th, yes.
Judge, he's indicated he's indicated a week's worth of this access log that consumes a number of pages like you're seeing on the screen in front of you. It's not explained. This witness, with all due respect to her, Ms. Hanson, is not one who created it or maintains it or who is even familiar with it. And it's being offered out of context, without explanation, without foundation. I don't know what he's intending to show with it, but I know two things. Number one, this thing, if you look at it, is about 10 columns
Says who
of
created
different
this?
pieces of information that are within the purview of the information technology department. not the social work department.
Guys, get your screenshot
This
there.
lady who's he's going to use it with has no involvement.
I can't even read it. I've got it blown up on my screen.
No involvement with having any part of it, and it's very unclear what he intends to do with it. It is clear that there has been on multiple occasions raised through this case an allegation that this access log documents a HIPAA violation. We've had it. You'll recall that we had a motion on that, a motion in limine on that. Your Honor asked for a brief from the plaintiff in response to our motion in deferring ruling on it. That brief was never forthcoming, and it's never been ruled on. So pending that ruling and pending clarification and a proper foundation, we object to this exhibit.
This is, if the court may recall, there were corporate records custodians which were waived, so the corporate records exception to the hearsay rule was waived. Not only that, this is a 803.18 admission, since it was created, I don't think there's any dispute, created by Johns Hopkins All Children's Hospital.
Well, tell me how you're going to use this.
I intend to ask her.
And who are you asking?
Judge, now that I think about it, I'm not going to use this with her. I just want it in evidence so that I can ask her about procedure.
From a 30,000-foot view, I don't have a problem with the access log, assuming that it is the access log of who was looking at the medical chart. I don't.
I join Your Honor in that position. I don't have a problem with the access log, but I got a problem with this witness in the access log.
I don't believe this witness will be able to identify Sally Smith's specific entry. So I do not intend to ask her to try to do that and waste the time of the court or the jury. However, I do not want to draw an objection about facts not in evidence or something else, because I have the right to tie this together later. But as long as this is in evidence, then I should be able to explore Johns Hopkins procedures. This is the only witness that I've been able to get from Johns Hopkins to testify.
And who is this witness?
Debbie Hansen, the only former employee of Johns Hopkins.
Well,
Judge, there's going to be strenuous objection over the foundation for her knowledge about some of this stuff. I don't know what counsel intends to ask her about, quote, procedures, unquote, but I do know that her job description doesn't contain and doesn't involve information or procedures regarding access to medical records.
Well, on the issue of what might be an unpled HIPAA violation count, are you going there at all in this case?
No. Well, we're going to argue it, but I'm not going there until we have a ruling from the court one way or the other. So what I can ask about is patient confidentiality, and based on the patient statement of rights, which is that in evidence? That's in evidence.
Yes.
So I intend to use the patient statement of rights and instructions she received at Johns Hopkins at or around the time about how to maintain patients' privacy as to records. Now that's an admission, party admission.
Well, I don't have a problem with this document as it exists.
This is getting so good.
I just don't.
Judge, again, I don't have a problem with this document per se. I have a problem with excerpts of the document as opposed to the whole document if we're going to go here. But there's no question that we created this. That's part of our corporate records. The question's going to be ultimately whether the witness he's trying to put on to do this has any competence to address this.
Then why can't we just put in the whole access log? I'm assuming 2165A is the entire access log for Maya Kowalski's stay.
2165A, Your Honor, is a subset of the access log from October 7th to October 14th. So it's relevant to that first week.
And incidentally, Judge, there isn't any question that Dr. Smith did in fact access Maya Kowalski's medical record on or about, I think it was the 8th of October, and that can be covered with her, and doesn't need to be covered with this particular witness who testified her deposition that she had no contact with Dr. Smith on this. So I'm not sure where counsel's going with any of this, but the bottom line is I don't have any problem with the entire access log, but that access log is many multiples of what this is.
Okay, so Mr. Whitney is telling me the 2165A is for a period of what, 1 week or 2 weeks?
1 week, Your Honor.
Is there an exhibit that has the entirety of Maya Kowalski's stay?
Without looking, 2165, I can find the joint exhibit list. It's at several hundred pages, but I believe 2165 would be that document, Your Honor. And just one moment.
Then why don't we just put in the entirety of the access log?
Yes, Your Honor, it's 234 pages, and that's the entirety of it.
And that's 2165?
Yes, Your Honor.
So, Mr. Hunter, instead of putting in A, do you want to just put in 2165? I understand that you don't think that this witness can talk about 2165.
He's already said.
Yes, sir, Your Honor.
So, plaintiffs, are we moving in 2165?
We move 2165 in.
So the whole record goes in.
We have that one.
Amber, you're going to get it.
You don't have 2165A. They're all marked as 5A. You don't have a plain 2165.
We haven't submitted, I guess we haven't submitted the entire. We can submit the entire, Judge, at the appropriate time. We just need to print it out.
Okay. So we seem to be falling behind on your exhibits. So we still need some flash drives with videos.
Your Honor, all the ones that have been admitted last week, we have received.
You did receive them this morning?
Yes.
Okay. So you can bring 2165, the paper version tomorrow?
Yes.
Yes, Your Honor, we will.
Okay.
Right.
But you have it electronically, right?
Yes.
It's like a whole ream of
So the
paper.
court will receive 2165.
Do you want to go back to that one?
Okay. It's past 9 o'clock.
And 203419, the list of meds found by the detective. It is an objective fact that it does not contain anything, and he can testify to the contents and where it came from to lay a foundation. It is part of the police file, but it contains no narrative.
Let's put up 2034, page 19, please.
Here you go, Amber. Get your screenshot.
Is it just this one page?
Is there a second to this? It says page 2.
It's a 37-page exhibit, Your Honor.
Well, Judge, this is the medical examiner autopsy
hang on.
report.
The 2034, the entire report, the court was correct about the refreshing recollection. However, this particular exhibit, 2034-019, we're asking the court to allow this portion of it in because it is an objective statement of fact. It contains no narrative, and it is a public record.
Your Honor, we'd object. As part of the medical examiner's report, I don't know who created the list.
That's what this witness is going to testify about.
Well, the prescribing physician.
Well, Judge, he can refresh his recollection with it, but I don't know why the actual part of the report would come in. Yeah, he's not part of he's not the medical examiner investigator. He's part of, the witness is with the sheriff's office. And this is the medical examiner's report.
Judge is angry because
all of the data for the medical examiner's reports like this. That's the point.
This looks like a summary.
No, this is actually, if I can lay the predicate with the witness, I can demonstrate to the court.
What witness are you talking about?
Detective Siborowski. They might just murder that.
Solberek.
Solberek. Garrick and Solberek.
The judge needs another weekend, like right
How
now.
are we using this?
It literally says investigation
Relevance,
summary.
Your Honor?
I'm sorry?
The relevance?
How are we using it?
I want to have him identify it, explain how it was compiled, and then comment on the contents of any and all, after a sweep of the house, any and all medications, prescription medications that were found in the house, relevant and material to the allegations that Beata Kowalski was infusing ketamine to her child at home. And this is after they found everything in the house and everything in her car.
But I didn't let the defense test the remaining fluids for the presence of ketamine.
I didn't think that by the time they got around to it, my understanding from the detective was that at the time it was taken, there was a request by him to have it tested. And I understood that by the time we got into it and that had been requested, that the results were it was not available, that it was too long, it wouldn't have shown anything. Now that's just my knowledge of it, and I don't recall the specifics of their motion.
Well, my recollection of how we dealt with this issue was the fact of the suicide is not really in contest here. And is the defense going to be contending at trial that somehow, either through intravenous or oral, she gave herself ketamine, she being Beata Kowalski?
Judge, the potential did exist as a result of what plaintiff said in opening about this issue. Your Honor will recall that we attempted to get vitreous fluid tested like 2 years ago, and the objection at that time was that it was irrelevant, and Your Honor sustained that objection. The fact of the matter is that the IV, certain empty syringes that were found on the decedent's body, and the saline bag, as well as its tubing, that were in the autopsy pictures, were not preserved, and they were not tested. The vitreous fluid is still in the medical examiner's locker, and it was not tested. There have been, as I told Your Honor, 2 witnesses who have said that there was dosing of ketamine going home through the port, going on at home through the port, and the evidence will be, if it needs to be, that there is a dose of IV ketamine that was filled, a prescription for IV ketamine that was filled while Maya Kowalski was in the hospital and not able to have it administered at home, that to this day remains unaccounted for. So that's the universe of proof here, and I'm not sure, I mean, it either needs to be irrelevant or relevant, and you know, we keep going back and forth.
Here's my thought process. The biggest issue in my mind was what the defense was going to try to do is make an inferential leap that somehow Beata Kowalski was administering ketamine to Maya at home. And if Beata Kowalski had ketamine and administered ketamine to herself as part of the suicide, how that she still committed suicide. She still died by suicide. And so I don't see why the ketamine issue for Beata Kowalski is an issue, nor do I really see all these other medicines. Why is that?
Because there is an allegation in this case of Munchausen by proxy, which has not been abandoned by the defense. The key to their Munchausen by proxy claim is that Beata was pushing a lot of medical treatment on her daughter. This demonstrates, including the fact that there was a prescription 2 years old for 15 hydrocodone and 13 still left. There's a prescription of Xanax, 30 and 30, all of them left. This demonstrates that there was absolutely no misuse of any type of prescription drugs in the house. And it goes to our point that Beata Kowalski was a very careful nurse and that she monitored all of this. And the reasonable inference from that is someone like that is not going to violate the orders of a doctor and administer ketamine IV at home. If the court will recall, the prescription was for IV ketamine, but on it, the method of delivery was orally. And the testimony is they put it in grape juice or Gatorade so that Maya could take it orally. Inefficient, but in emergencies, that's what they did. And the evidence is undisputed about that. There is absolutely no evidence whatsoever that Beata Kowalski ever injected Maya Kowalski at home. None. But this goes to prove her propensity or whether in the normal course of their living practice at home, whether Beata Kowalski, Jack Kowalski maintained care and control of their prescription drugs. And a reasonable inference could be from the jury that this kind of person is not likely to do anything like that.
Well, how is the detective going to, deal with this record?
He is going to say, we swept the house, we swept the car, we were looking for any indications with the IV bag and all that. We were looking for any indications of whether Beata Kowalski had given herself medication or whether there were any indications of unprescribed medications around the house. It was the typical thing that they do. It's their usual procedure, especially in a suicide, because they find pills, the means of suicide. Here it was fairly obvious, but again, people were wondering, and I'm concerned about the jury speculating about what Beata Kowalski may or may not have given herself at the time. There is no evidence whatsoever from the autopsy or any direct evidence anywhere that Beata Kowalski injected herself with ketamine or anything else. The speculation might be that she gave herself something to knock her out so it wouldn't be quite such a, and it's not speculation, it's a reasonable inference, that she gave herself something that would make it easier to go through what she was about to go through.
Anything further, Mr. Hunter?
No, sir.
Mr. Anderson has convinced me that there is some relevance to this document to rebut a theory of Munchausen syndrome by proxy. Now, as far as its use by this witness, is he going to testify that he or she went around and pulled all these pill bottles? I mean, there's a lot of information on here that looks like a summary.
I believe his testimony, I haven't spoken to him about it, is that either he or someone at his direction, there was another police officer there. I don't know that he swept the entire house himself, but someone under his direction and control swept it. There was a representative of the medical examiner, there was another police officer there, and I wouldn't say that this is so much a summary, Judge. This is an accurate portrayal. What I can't tell you is that whether he personally counted out every pill, but it was all done under his investigation and control.
And it's only this one page?
Just this one page.
I'm going to go ahead and admit in page 19 of Exhibit 2034.
Kayla, thank you very much for the
anything that we have to do
1 month message.
Because we're now 16 minutes beyond the time.
17 minutes.
Not in our view, Your Honor.
Emma Elizabeth, thanks for gifting the membership as well. That went to Hippie Chick. Congratulations, Hippie Chick.
I've got all this stuff in my mind. I need to get it out as soon as possible.
Hopefully maybe towards the lunch break.
Yeah, I really... Well, I've got it all here. Got it all flagged and highlighted, so...
Judge has a ton of stuff he needs to do. And these jurors, these attorneys with their specifically Mr. Anderson, I believe, with his lack of ability to organize and his lack of paralegal, because Kelly's out, has really cramped to the judge's style this morning. So we'll see how that affects how the arguments go today. Selena K gifted 5 memberships. Thank you very much, Selena. That is wonderful of you. Appreciate that. Aaron Patterson says, woohoo, 5 months in and still loving it. All right, and the mods are the best. Thank you so much, Aaron. Thanks for the kind words for the mods. They definitely deserve it. Let's see. Gifted memberships went to, from Selena, they went to Dallas K, BG, Calypson's Vixen, that's Amber, Mike Savage, and Wendy Alexander. Maya's not here today. She probably won't be here tomorrow as well. I'm just guessing.
Good morning.
Because of the content.
Have a good weekend. Glad to hear that. I want to confirm while you were away, you did not discuss this case amongst yourselves. You did no investigation. You received no information. Is that correct? Since the last time you were with us, has anyone approached you about this case? No. Okay. Since you were last with us, have you seen any media coverage about this case? No. Okay, thank you. Mr. Anderson, call your next witness, please.
Special attention. Plaintiff's called former detective Yarek Solberic.
Butchers his name. Solberic. That's what I called him. So we're going to have this problem again tomorrow and the next day, as the exhibits the defense is going to be using during the testimony of the 2 doctors that are going to be testifying the next 2 days are extensive, and they have not prepared, just like they have not prepared for today. They provided the list of exhibits at the last minute, at noon, 6, and 9 p.m. at 3 different times yesterday to the defense. The defense needs more time to prepare and object. So it's going to continue for the next couple days, this little circus in the morning. The judge is not going to like it.
Good morning, sir.
Good morning.
Good morning.
Please state your name for the record.
Yarek Solberic.
Let me make sure. Solberic.
Solberic.
Can you spell that for us real quick?
Yes. The first name is Jarek. Last name is Szalb as in boy, Irak.
Thank you, sir.
Somebody get that for me?
Now, sir, are you being called here as the investigating detective at the Sarasota County Sheriff's Department for the suicide of Beata Kowalski?
Yes.
And can you tell us, are you still with the Sarasota County Sheriff's Department?
I retired from the Sheriff's Office.
And approximately when?
March of 2020.
And at the current time, you work for the Department of Defense, is that right? Or a government agency?
I work for the federal government, yes.
Work for the federal government. And so I want to take you through a little bit of your background and training in terms of your job as a detective that you brought with you into this investigation. First, tell the jury how you started with this. Was this through college or a school or what?
So I started in 1994. I went to the academy, and I started out working in the jail, then went to patrol, and then to detectives. Last 16 years of my career was as a detective.
And what year did you finish the academy then?
There were 2 different academies. So one was in 1994, and the other one, I want to say it was like 98 maybe. I don't recall.
Okay, and since that time, have you had that, in between now and then, have you had the opportunity to attend any continuing education? I'm not sure what it's called in the law enforcement business, but...
Yes, it's continuing education. So constantly, especially as a detective, we're constantly sent to different schools to improve our skills.
And have you attended and I'm not sure how it's called, a training for It was either at Suncoast Septical College, training for police officers was where the first round was?
Yes.
Okay. And did you then go back to another series or seminars that dealt with witness investigation and interrogation?
Yes.
And what was that called?
I attended numerous schools. The latest one that I attended was National Center for Credibility Assessment.
And where is that?
That's in Columbia, South Carolina.
And how long is that?
Approximately 4 months.
And once you attended that, did it reinforce many of the techniques and knowledge that you'd gained previous to that?
Yes.
So what were your duties and responsibilities as of January 7th of 2017?
Okay. So I was a detective in criminal investigation section for the South District of Sarasota County.
Okay, and what did that involve?
Basically investigating any major crimes to include any death investigations.
And were you a resident of Sarasota County at that time?
Yes.
So are you still?
Yes.
How long have you lived in Sarasota County?
Since 1990.
All right. Now, I understand that as part of your duties as a detective, you investigate deaths.
Yes.
And tell the jury approximately how many deaths over the course of your career in Sarasota County that you investigated.
I approximate about 500 scenes that I responded to, death scenes.
And out of that 500, can you give the jury an idea of how many were involved a suicide as opposed to some form of other violence?
I would estimate that most of them were suicides, so probably north of 90%.
And so before we get into the specifics here, when you're investigating suicide, and I gather you did this all the time, what were you looking for upon arrival at the scene?
Okay. So when we respond to any death scene, the reason why we're there, a detective is there, is to make sure that there is or there is no crime. So we always walk into it, or at least I always walked into it seeing, okay, is this a homicide? And then looking for clues to prove or disprove whether it was or not.
And so on this day, would it, for your benefit, was a report prepared in connection with the suicide?
Yes.
Would it refresh your recollection to be able to refer to that report?
Yes.
Do you have it there in your possession?
I do.
Judge, do you need me to broadcast over here as well, or just go with that?
So long as they know what he has.
Right.
You need to.
Mr. Hunter, do you want to look at his report?
2032 or 2034.
It is. It goes from 92 000 on base numbers 00092 up to
Maybe a closer look at it, though.
Sure.
128.
Detective, if you could show Mr. Hughes what you're looking at.
Yes, sir.
Sure. Mr. Anderson.
Somebody turn the faucet on. There's a sidebar. I believe I'm going to count that as an objection because I think it was asked for by the defense. And I think I missed a couple objections this morning anyway. All right. Yeah, there's not much we can do about the use of the terminology today. I prefer to say something like took her own life or something like that instead of saying suicide. I think the biggest impact is that YouTube tends to just punish the creator, the content creator, when there's a lot of content like this. So I'm taking a loss on this one today. That's fine. We have to cover this, and it'll be all right. But that's just I'd say more than my concern about using the term suicide in chat or that. How we talk about it is more important to me, as in a respectful way and being kind.
And when did you arrive on the scene?
If I may refer to my notes, please. Turn to that page. So January 8th, 2017, 8:50 hours, so 8:50, just 10 minutes before 9 a.m.
And what was the first thing you do when you arrived there?
Well, usually the first thing that I do is when I prepare for responding to a scene, as I'm getting ready, get that call, I always ask for the 911 call. So you listen to it on the way there. Once I arrive at the scene, I'm always briefed by a patrol deputy who's responded there. At that time was Deputy Leo Ayden, who was personally known to me because he's worked with me as a detective in criminal investigations.
This officer before? Had you worked with this officer before?
Yes, he was a detective in the same section that I was in for a number of years.
And can we please publish, with the court's permission, 2031-003 in evidence?
Okay, we're gonna.
Which number is this?
We're gonna hold it out like this.
Isn't police tape photo in evidence?
This one was not in evidence.
Tell me the number again.
He did not ask for this one.
2031-003.
I don't think that one's in evidence.
It's not.
Can we just show the witness? I'll have him identify it, and then I'll move it in.
Can we have the number again? I'm sorry.
It's the police tape.
2031-003.
2031 are photographs, Your Honor.
Never mind. So, is a yellow tape put up around the house to secure it?
Yes.
And what other steps are taken to ensure that nothing comes in or goes out, other than the officers?
Right, so there's usually at least one. In this case, I remember there were two deputies. They hold the scene until criminal investigations arrives, and if anyone's in the house, they usually stay with the person in the house and make sure there's nothing disturbed with the scene.
And what do you do in terms of the contents of the house?
So whenever we respond to a death investigation, I go through the whole house and just look at the totality of anything suspicious, anything disturbed, meaning is there any evidence of struggle, any fights, any evidence of a crime being committed. The other thing that I always look for is any drugs, medications, anything that would be illegal in itself.
And did you find any evidence of an altercation, overturned furniture, anything like that?
No.
And then did you also sweep the house to determine, like you said, not only the medical cabinets, but in other areas where there were any prescription or non-prescription drugs?
Right. So because people store their prescription medication different places, whether it's the bedroom or their kitchen or sometimes their bathroom, I go through everything looking for, again, any evidence of any medications. And there's two reasons for that. One is I want to know if they had taken anything. Second is I collect any medications because it goes to the medical examiner's office with the victim.
And would that include the victim's automobile, the Prius?
No.
So would the medical examiner then perform that task of inventorying the Prius?
Also speculation.
If you know.
Can you repeat that? Can you repeat?
Yeah, going through the car itself to find out if there's anything in it of interest.
So I went through the car,
and
there was nothing of interest or anything that medical examiner needed to have.
Okay. And refresh your recollection, although you might have it here, a list of the medications found by you?
Yes.
Can we publish 2034-0019?
Yes, you may.
I think we're being very careful about what is shown here.
All right. Now, if you could, it's a little hard for me to see, so I'm going to bend down. So this tells you the date it was filled, the amount issued, and the amount remaining. And of these, going down, to the best of your knowledge, the first ones, the nortriptyline hydrochloride, the citalopram, the levothyroxine, and the, however you pronounce that next one, are those narcotic drugs you would be concerned about?
No.
Then zolpidem tartrate, is that Xanax? The next one?
He doesn't know.
Oh, no. Are you familiar with that as a sleeping aid? Sorry, Ambien.
Yes, and that is not a scheduled narcotic.
Mr. Anderson, I need to cycle the TV again. 1 second.
We're going to turn it off and on again. Give us a minute.
Is it working?
Try it again. I don't know the answer on the public TV. I'll try to have it looked at, but let's proceed.
So the zolpidem tartrate, is that Ambien?
Yes.
And so how many did you find? Or issued? Excuse me, how many were issued first?
I'm trying to put my eyes on it.
It's 1, 2, 3, 4, 5. So I believe it's 5 now. This is all beginning.
Yes, so it looks like there were 20.
Tech support's
30
here.
issued
Fix the
and
TV.
5 remaining. And if I may, please, so I have to count every bottle, how many pills are in there, and record that.
I see. So you went through the bottles to see.
Every one of them.
Every one of them. All right. And so it shows 1 tab at bedtime. And based on your review there, did it appear that these were being taken according to the prescription?
Sustained.
What date was this prescription filled?
It looks like it was filled on October 10th, 2016.
And how many months prior to this was it filled from the date you inspected it?
Approximately 3 months.
And there were 30 issued for 3 months?
Correct.
Next, going down, if you recognize it as a controlled substance, let me know. But then there's alprazolam. Do you recognize that as Xanax?
Yes, that's Xanax, and it's in the group of benzodiazepine.
And are you familiar? Is it a scheduled drug?
Yes.
And when was it filled? Filled.
Let me put my eyes on it. I apologize.
January 21, 2016, I think.
Objection leading.
I see it. I got it. So November 21st, 2016.
All right. And so this was, again, approximately 2 months, a month and a half before the death?
Yes.
And how many were issued and how many were remaining?
So issued on the bottle said 60, and there were 60 in there.
And so then, if you move down, unless you recognize any of those as controlled, an oxycodone, and it was, in the interest of time, issued November 21st, 2014. So that would have been how long? A little less than 2 years before?
Yes.
And how many were issued in 2014?
So there were 15, and I counted 13 in the bottle.
Did that indicate to you that over the course of the preceding year and 3/4, only 2 had been used?
Yes.
Let me ask you, from your training experience and investigating 500 suicides, if there is if you find striking, what are you looking for if there is a belief or suggestion that there's been any involvement of overuse of prescription narcotics or misuse of prescription narcotics?
So somebody who's dependent.
Overruled. You can answer.
Somebody who's dependent on drugs usually doesn't keep them, hold on to them. They use them, and that would be true of any opiates. And what I've found in the past is not only will you find empty bottles that were recently filled, but also multiple prescriptions that were filled at the same time by multiple doctors, doctor shopping.
And did you find that in this instance?
No.
So then, through the course of this, did you find any cell phones?
I did.
Can we show 2031 dash, I thought it was 007, but I want the phone. 11? Yes, with a note on it. 0011?
So 2031-0011?
Yes, sir. Hang on. It's 2031-0011. Or 011.
2031-011.
The defense is having to read off
Yes.
the plaintiff's exhibit
Maybe publish this.
numbers.
So
I think
tell
this
the
is a
jury
cell
what you
phone.
found here and where you found it.
So this phone, I believe it was in the laundry area just preceding entering the garage.
No, it says retaliation.
And, it was a phone with a pink case, and during the investigations I learned that was a phone that Beata was using.
So then you continued on, and can you describe then the scene of the suicide?
Okay.
Yes. So I entered the garage, and the victim was suspended by some belts from the structure of the garage door, so the rail.
And I believe we have a photo of that. 20. What is it?
We're going to make sure this is not shown.
Okay. Well.
At 019.
That's what?
019.
019, Your Honor. May we publish?
Yes.
I'm just telling you that they have not shown it on the stream yet. I'm pretty sure they're not going to, but I'm not going to take a chance. The judge has asked them. So we're seeing Jack instead right here. And he's got his eyes closed.
The scene.
Yes.
And so describe for the jury what you saw there that may be depicted in this photo.
So I saw the victim. I saw the belt that she used. And there is a ladder in close proximity to her. And then you also see a line that is going from a bag with a solution that goes into her left arm.
Okay. Now, I want to switch then to a. Did you find a small plastic pan, if you will, that contained some materials a nurse would use?
Yes.
We have that, and it is for the record.
The children are not in court. Only Jack is there. Jack has his eyes closed during this display.
Same 2031-023. May we publish?
Yes, can you take that down for a second? Ms. Reyes, you're on A series as opposed to the regular series. Gail, hold on a second. I need you to tell Mr. Anderson, I need Mr. Anderson and the attorneys to approach.
So we have a sidebar going on right here. The judge called this one. I believe it has to do with the method they're showing the pictures, that they're exhibiting from the wrong source, I believe. So we'll see if he can get this fixed. The judge is super frustrated with all these exhibits this morning, with how the defense has taken forever to even provide which ones they're going to be using. I'm grateful. It's great to see. I'm watching two of the major feeds right now, and it's good to see no one is showing the images as they're displayed in the courtroom, even though they're publicly visible, and that the option is there. That's good to see. Interesting. While they're talking, interesting little side note. I saw actually it came through one of the law and crime personnel's Twitter feeds, that a judge in one of the cases they're following has ruled that the media may show the jurors' faces if they wish, meaning if the media wishes. And he says, I've done all the research into the legal precedents, and there's no rule preventing you from showing the media's face. What do you think about that? What do you think about media showing jurors' faces during trial? I think it's a terrible idea. Terrible. BK is not going to start for a long time, Samantha. I know that Sarah Boone was originally slated for today, but then they sort of pushed it off, but there was never a new date put in the file. So it still shows that her trial begins today, which I don't think is the case. But that's the only one I know about today. BK will be lucky if it starts next year.
All right. Again, let's take the jury through what you saw on this one that's in evidence. Unblurred. 2031 is the unblurred, correct?
We're going to make sure this doesn't accidentally get shown on the screen. You can see on my screen here what we're looking at, but...
All right. So tell us what we have here.
So this was some alcohol pads. There was another syringe and gloves.
So what did this indicate to you, knowing that she was an infusion nurse?
It appears she was a professional and handled
this
those
objection
as a professional would.
Even when she was planning to take her own life, apparently. Yes. All right. And so what was the means of strangulation here? How did she go about it other than just having this around her neck, the belt? And was this a wide belt or a narrow belt?
It was a wide belt.
Okay.
So any death scene in Sarasota County is going to fall under the jurisdiction of the medical examiner. So as a detective and investigator, I put all the pieces of the puzzle together, and it is the medical examiner who actually renders the cause of death in any case.
And what did it appear to you from your years in investigating these, how Beata managed to get herself up there and then get any support out from under her?
Objective foundations for the purview of medical examiner's office. So it appears that because of the proximity of that ladder to her, I would assume that she probably used that to step up and use it to create the belt in which she was going to hang herself with, and possibly stepped off of that to put the pressure on her neck.
And so during this period of time, from your training and experience, is there a range of time it can take for people to strangle?
Sustained on that one.
Through the course of your training, have you taken courses in which different forms of suicide are explained?
Yes.
And did any of those courses, and if you can elaborate, fine, but did any of those courses explain about strangulation death?
Yes.
And did any of those courses also explain different forms of lack of oxygen, such as drownings and other ways that O2 fails to reach the brain?
Yes.
And had you, prior to this, investigated a number of suicides by hanging?
Yes.
Approximately how many? Just a rough guess, if we can. I mean, how prevalent was that?
Well, it's very prevalent. Most of the death scenes we go to, if you live in Sarasota County, you know that we don't have that many homicides. So most of the death scenes are going to be your suicides, predominantly, overdoses, accidental. Those are the majority of it.
And so in this instance then, would you be able to tell from the information you had how long it would be between a few seconds to a few minutes? Or would that be in the range?
As well as foundation for the medical examiner.
Sustained.
How long have you been trained to understand that it takes for brain activity to cease in terms of a suicide situation of strangulation?
Objection, relevance, purview of the medical examiner.
Sustained.
I'll get it the other way. All right. So you saw in evidence a phone on the dryer there, and so did the fact that it strike that? Did you also listen to the 911 call?
I did.
And based on, and did you have the opportunity to interview witnesses, including Mr. Kowalski?
I did.
And from the interviews and the 911 call and the physical description, were you able to determine what the term retaliation, if not specifically, but generally referred to?
You overrule that one. You can answer.
So, in my experience before, in the cases that I work, retaliation usually implied that there was somebody that was causing whatever drove the person to the suicide, finally give up and take their life. And I vividly remember one case here in Englewood where a husband and wife, they were having issues, problems, and the husband said, I'm going to show you what...
Sir, let's not talk about other cases.
Okay.
Thank you.
Just from your
The judge
experience
objected.
then, what, and your training, I mean, what are you looking for in terms of the motives and thought processes of the victim leading up to the suicide? And is that part of your investigation to try to figure out why this happened as well as how?
Yes. So...
Relevance. Overruled. You can answer.
So the first thing I always do is walk in, look at the scene to see what I have. Once I'm satisfied that there's nothing suspicious, then I will start doing my interviews. And I did interview Jack after walking the scene.
And did you learn from that interview that there had been a stressful and emotional situation going on with their daughter being kept at a hospital?
Hearsay. Overruled. You can answer.
Yes. So any of those suicides, me and the loved ones always want to know why. Why did this happen? So I look at that. The first thing that Jack told me was that in October of 2016, they went to All Children's with Maya with severe stomach pains. He informed me that the hospital did not feel that Maya had any disease, and actually accused his wife of Munchausen by proxy. And as a result of it, she was not allowed to see her for 3 months. So that was the first thing that he told me, which indicated to me as a father that was probably causing her a lot of stress.
Psychological stress.
Yes.
That we're talking about here. And in your training and investigations of these suicides, have you had the opportunity to speak to or interview people who have actually, for lack of a better term, survived suicides, Baker Act people, or
yes.
so forth?
So one of the responsibilities that we have as deputies and detectives is placing somebody under Baker Act. And basically what that is talking to the individual when they are attempted a suicide.
Sustained as to that question.
Well, based upon your investigations and research into these causes, what have you found to be an overriding rationale among the victims that you have interviewed, the surviving victims you have interviewed?
I sustain that one.
What, if any, you know what, I'll move on. So, through the course of this, did you find in the house any indications at all that Beata or Jack Kowalski or anyone else had been using any drugs of any type in an illegal or unauthorized way?
No evidence of that.
Now the jury will be curious about the IV bag. What was on the outside of the IV bag? What was it?
So it was a clear fluid. Give me 1 second and I will tell you what it said. Sodium chloride.
And that's salt water?
Yes.
All right. And so was this did you look at this as a clue or a reason in any way for why she took her life, or was this something you looked at more from I don't know, a practical way and explain the significance to you?
Overall, you can answer that one.
So she was an infusion nurse, and I really don't know why she used the injection. I couldn't figure that one out, but every suicide is unique and unique to that person, so it might have had a meaning to her, but I don't know what that was.
And so did you have the contents, as much as you had of these different things, delivered to the medical examiner?
Yes.
And did you receive any reports back? I understand as to the injector there that evidence was not preserved, as opposed to the bag.
Yeah, so that goes to the medical examiner's office, and I don't know what Dr. Vega did with it.
And from everything you saw and heard, was there any indication of any other cause of death other than hanging, that is, strangulation?
Right. So the totality of the investigation went to Dr. Vega. He did his part, which he made a report, and his conclusion was that Beata hung herself.
All right. And through the course of this, had you had the opportunity to review the backgrounds to determine whether there was any history in the records of child abuse or domestic violence on the Kowalskis?
Yeah, there was no indication of law enforcement responding to their house for any domestic violence or.
I've turned on the clicker for the objection counters.
And so,
there are little clicks when it happens.
Did Beata Kowalski leave suicide notes?
She did.
And court's permission, may I publish 2032?
We are going to be seeing these notes. Just want to be aware of that.
12 and 13, suicide note number 1.
Yes.
I'd like you to take a look at this and tell them what, if any, significance this had to your investigation.
All right, so we talked about the why, and Beata wasn't there to tell us this in person, but she certainly left 2 notes, and this is one of them. So as I was looking at this note, I'm picking out her state of mind, her mind frame. The first thing that says in there, it says, take care of Maya. And she also expresses her love for Kyle. In that note, what I focused on as to her state of mind, one of the last sentences, I no longer can take the pain being away from Maya and being treated like a criminal. I cannot watch Maya suffer in pain and keep getting worse while my hands are tied by the state of Florida and the judge. It's been 3 months today of Maya not being home. So that kind of shows what her state of mind is and the pain she was going through.
All right. And so in the event of her death and Jack's death, did she say who she gave her parental rights to in the event of both of their passing? I gave
Yes.
my parental rights.
To her sisters and brother in Chicago area.
And then she wanted to be cremated.
Correct.
Is that right?
Yes.
Okay. Let's and did this further confirm your theory, but the results of your investigation as to the why of this?
That gives us a really good clue. That gives us a really good clue as to what she was going through emotionally. The depression, being in pain, in emotional pain, and no longer can take that pain.
Then, if we could, Judge, publish 2032-14-15, suicide note number 2.
This gets around because of the dying declaration exception.
All right. And so, what was significant here to you, if anything?
Okay, so my attention came to the very first sentence where it says, all children hospital and DCF have destroyed Maya physically and mentally. She said, you let them continue to destroy her even more slowly each day. Maya will never be who she was before October 13th, 2016. And then she went on to say, by taking the side of all children's hospital and DCF, you have destroyed my family, my marriage, and you have put us into bankruptcy.
Now, did she give some idea down there, second from the last, about her history, personal history, that was significant to you? I grew up in Poland.
Yes. So she talked about growing up in Poland and watching the communist and socialist system being a nightmare, referring to taking away people's rights. And she felt that's what she was experiencing here.
And after reviewing all of the materials that you looked at in your report and the results of all the investigations, was there any doubt that the cause of death, from your perspective, was a strangulation, suicide by strangulation? From his point of view.
Overview, overruled.
Right, so from my experience and training, it appeared to be what it is, an apparent suicide by hanging.
Oh, yes, I missed something. Go to the second page of 015. That's pretty important. Let's go over that. So let's go down to the I hope.
Yes.
I should have added that in before.
Yes. She said, I hope that you will make sure that Dr. Malik at Ultra Hospital and Sally Smith will lose their medical license and never ever hurt another child again.
Very good. And
They all start with I hope on that page.
didn't you say anything else after that in the next paragraph?
She said, I hope that my family will be able to hug and kiss Maya soon, since you have denied me to execute my parental rights towards my child.
Thank you. May we approach for one moment on this procedural thing?
Okay, so we've got the water going in the background. I'm just going to mute it and watch the levels to turn it back on once they're done. Those notes are incredibly tough to read. Yeah. There we go. They're done. Nope, they just turned the audio off finally. Thank you, audio guy. The white noise makes you want to sleep. You know, my kids like sleeping with a fan, and they'll sleep in front of a fan, and then like be wrapped up in blankets because the fan makes them cold. So I think they just like the white noise. I might need to just invest in a white noise speaker for them. It is a heavy morning. It's been spicy. A lot of battles, legal battles, and a lot of what appears to be just sloppiness or unpreparedness or failure to comply with discovery orders. And it could be positioning. The plaintiff is right at the last minute giving the defense, like literally the last minute right before the jury walks in, the list of what they want to use during that day. Out of the 80 binders, I think it's like 9 boxes worth of evidence, thousands and thousands of pages, and they're not giving them a head start at all on any of this. So it might be strategic, but the judge is tired of it, and he's not going to put up with it for much longer. Red Pen, I'm just saying it was 58 degrees last night, and I've got kids that like to sleep with the fan blowing in the air from outside into their room, just fresh air into the house, and they're like bundled up like Eskimos at night, but they won't turn the fan off. Oh. Yeah, I think it's pretty clear what Beata's intention was with those notes. I don't understand the infusion side of it and what that meant. Apparently, it's all just speculation right now because it wasn't tested, so nobody knows. There appears to be no other evidence that there was something else injected in it, like nothing blatantly stand out that there was another medication or something that was included in it. But it's reasonable probably to assume that something else was used. That is Jack. That's Maya's dad, Beata's husband.
Your witness.
Good morning, sir.
Good morning.
previously asked about a suicide letter.
Yes.
Just a moment ago. Do you remember that testimony?
Yes.
Who was that suicide letter addressed to?
Which one are you referring to?
The last one you were just speaking to, Mr. Anderson, about.
That letter was addressed to Judge Hayworth.
You saw a picture that was identified at 2301-19 in your testimony. Do you recall looking at that photograph?
You're going to have to show it to me again.
Sure. Can you please put it up?
Yes.
Okay. We have it oriented properly. The top right-hand corner of this photograph, do you see a empty plastic bag?
I do.
Did you preserve that empty plastic bag?
Yes.
Where in your notes does it indicate that you preserved that plastic bag?
Everything goes to the medical examiner's office.
Are you aware what the medical examiner's testimony in this case was about the receipt of that empty plastic bag?
I don't.
Would it come as a surprise to you that he indicated he did not receive a testing?
Sounds like I'm going to have to sustain an objection.
Do you know what the results of the testing were for that empty plastic bag?
That would be something that Dr. Vega would be able to testify to.
If we look at this picture too, around the knee area, there is a syringe which your notes indicate had a clear liquid inside.
Yes.
Did you preserve that syringe?
That syringe went to the medical examiner's office.
Do you know if it was tested?
That's something that Dr. Vega would testify to since it's his responsibility.
Anywhere in your report does it indicate what the results of that, what the testing was for that syringe with clear liquid?
Okay, so as far as Dr. Vega, what he does, my report would reflect that when I received his report, and the last thing that said in my report that I'm going to make it part of this case file once the toxicology is conducted, then that report is made part of my case file as a standalone document. So I don't write anything else except for the manner and the cause of death.
So as you sit here today, are you able to say what was in the syringe with the clear liquid inside?
I cannot tell you that.
As you sit here today, are you able to say what was inside the bag in the up right-hand corner of this photograph?
I cannot.
Okay. In your report, I also saw reference to 2 additional syringes located under Ms. Kowalski's sweatshirt. Do you have any recollection about that?
I remembered that they were there, yes.
Okay. Do you know did you preserve those 2 syringes?
Again, that would have went to Dr. Vega with the victim.
As you sit here today, are you able to tell what the result of the testing, if any, in those 2 syringes were?
Again, that would be something that's Dr. Vega's responsibility, who would be able to testify to that.
Do you have any knowledge about what Dr. Vega tested or did not test?
The toxicology report definitely showed what he tested for.
Do you know if that toxicology report was testing Ms. Kowalski's bodily fluids or the contents of the syringes and bags?
Again, that's something that he would speak to. I wasn't there. I don't. I could look at the report. I could tell you what he tested for and the results.
Thank you, sir.
Anything else, Mr. Hughes? Hold on a second, Mr. Anderson. Mr. Hughes, anything else? Mr. Anderson.
And so, having been asked on direct examination about that toxicology report, can you tell the jury then what was tested for?
Yes, if I may refer to my notes. Give me 1 second and find that. Okay, so I am looking at the medical examiner's report, and it's titled Report of Autopsy. It enumerates a number of drugs that she was tested for. Two of the things that stand out to me in looking at the medications that I sent to the medical examiner's office are the benzodiazepine. I can't pronounce it right now. The alprazolam, the Xanax. So basically, that says there was non-detected. The other one that I was looking at is the opioids, which would be the OxyContin, and again, it says non-detected.
Move to admit.
Move to admit what?
Medical examiner report of autopsy, summary of autopsy, finding and options.
Let's go with exhibit numbers.
Say again?
Let's go with exhibit numbers.
Sorry. 2034-023. Just that part of the medical examiner's report contained within his report.
No, we would reject on the same basis that we did before the jury came in.
Open the door.
Sustained.
They opened the door and allowed it in.
So we should ask Dr. Vega, never mind. So, in this toxicology report, were there any indications whatsoever of any narcotics or other drugs that would have caused or contributed to Beata Kowalski's death?
No.
And as a practical matter, since she ultimately died of strangulation, would it have made any difference?
It's also speculation outside the purview medical change.
What if any difference in terms of death would the presence or absence of any type of narcotic or other drug make in light
Same
of
objection.
what you saw?
Same objection.
Sustained.
Were there any signs of any other cause other than strangulation?
Not to me. And again, I would have to defer to Dr. Vega, and in the same report that you're referring to, the cause of death is hanging, manner of death, suicide.
Mr. Hughes. Members of the jury, do any of you have any questions for this witness? I don't see any. May this witness be excused.
You may, Your Honor.
He may be excused, yes, sir.
Thank you, sir. Here you go.
Okay, so he's done. The defense opened the door on that one by asking about the IV bag in the photograph, and they showed just a cropped up version where you could see just that IV bag hanging. Clearly, the fact that it's empty would indicate that it was used, and I believe
next witness
that's
relatively short, or is it?
I don't know why the judge is concerned about the height of the witness.
Significantly longer than the last.
So this is a good time for a break.
We're going to take a break.
It would be a good time for a break.
Members of the jury, let's take a morning break. Let's try to keep it to 10 minutes. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
All rise, jurors exit.
Okay, we're going to keep the audio up here for a minute and see if they need to work something out with the two sides before we move forward and actually get our break. I thought he allowed it because
the jury's out of our presence. Are there any issues we need to address before we go on our break?
None by plaintiffs, Your Honor.
Okay, let's take a 10-minute break.
10 minutes. All right. While we're on this break for a little bit, they didn't open the door since the judge sustained the objection. What was happening was the the plaintiff had on redirect had talked to the detective and it said, since you were asked on direct about what was in the bag, do you have any evidence, from what was tested for? And so they were able to use them asking about, do you know what's in the bag? When defense says what's in that clear bag and what's in these needles, they were able to use the redirect to further go into that to say, do you know if stuff was tested? And that was what the defense objected to, and the judge overruled, and they allowed that part of his testimony, that report that just shows what was tested for, and the negative presence of those drugs, those two drugs, the opioids and what, Ambien or something, I forget what the other one was. So that information did come in, and that was because they opened the door. So we do have a morning break for 10 minutes. Yes, we'll go ahead and replace the pinned message there. Jarek Salzbarek, I don't even know how to say his name. It was a tough one. He was done. I think we have 2 doctors coming up. I know that. Let's see. Why do I have objections on the screen? Let's get rid of that for a minute. There we go. Okay. Debbie, I think we've confirmed that the buffering is almost always on your end. I don't know if getting faster internet is an option for you, but this one, I think that might be on your end again. Let's see. She may have been making a statement with the IV. I don't think so. I think she made her statements very clearly with her 2 letters that we saw. Very difficult to read, but very clear in what her purpose was and what she stated drove her to that. Clip the word what? That was a good what. I'll go back and get that. That was half an hour into the live stream this morning after court started. Let's see. No buffering here. It was symbolic. I think it was symbolic. I don't know. Both letters were signed. Live with passion. Live with passion. I don't think she was doing any hiding, like hidden messages anywhere. I think she was much more blatant than that. Laura Pertula says, finally yellow. I'm a bit behind today. I agree with you. Showing the jury is a very bad idea. Oh my goodness. Okay, so the judge that ruled that the media can show the jury if the media chooses to at any time during the trial, like show their faces as if they're the judge or an attorney or anything else, anyone else in the courtroom. I can see both sides. I can see that anyone who's a member of the public can walk in there and look at them. And they can be seen and viewed by that. But it's one thing to walk in and see a juror and maybe recognize someone you know. And it's another thing to have an image digitally captured and broadcast around the world in an environment where anyone can take that image and do a quick reverse Google search and possibly find you on your social media, identify who you are, and then it opens up to the entire world, everybody, your information. And the fact that you are dealing, what happens if this is a high profile case? What if this was the rule in say like the Murdaugh trial, where you have tons of people on both sides, massive interest. We had didn't they have the whole false alarm threat on? We had all sorts of stuff going on, I believe, during that trial. Might have been a different one where that occurred, but people are going to do stupid things, and if you put their pictures out there, they're going to be able to do more stupid things. They just haven't testified yet, Carolyn. There will be plenty of time for all that. There's at least another week of plaintiff testimony. Let's see. Laura, it sounds like the syringes were not tested. It sounds like the empty bag was not tested. And I don't know why. That'll be interesting to find out why. Okay. They're also able to tell who goes in and out of the courtroom. Easier to narrow down a culprit if anything should happen. It's got the lid on. See, we're good. We're good. Going back to the exit view so you can see where we're at, and we'll turn on the objections. Up to 260. Man, it really picked up this morning. We've had quite a few objections. P-Will, for real, I think there was some sort of statement, possibly in openings, or maybe it might have come up in a cross-examination where there was a insinuation that the mother was doing something illegal with drugs at the home. And so a lot of the testimony we got today was to counter that, to show that the drugs that were found, and there were a lot of medications found in the home, were at least had the appearance of being used according to schedule based on when they were filled and how many pills were left. So that was effective at sort of countering that argument. I'm not sure how key that is to the defense arguments, but I think it was done pretty well. Mel B, it should be today. I've actually got her page pulled up on my phone here. I'm just waiting for her to go live as we speak. Oh, she's live right now. She just barely went live a minute ago, and I don't see them yet. She has a whole bunch of roses and a little tiny display. New purse I haven't seen either as well. So lots of stuff on. We'll keep an eye on that and see if the flowers arrive here soon. I'm not sure if they'll be out today or maybe after lunch. We're on break for a couple more minutes, about 2 or 3 more minutes. Tiny flowers are the orchids. We're on Flower Watch. We are. We're looking for specifically a purple vase, a big purple vase. Listen to Lauren says, if I'm up around a jury, I'm buying a wig and wearing tons of makeup. That would be interesting. Is there any rule against that? You don't have to identify yourself, right? I mean, maybe when you show up for jury selection, but usually just the subpoena is enough to get you subpoena under driver's license and you're good. People, for real, we don't know. We know that a bag that was collected said saline solution on it, and that's about it. There was one up. I believe that there was an IV involved, but we don't know if there was anything else added to it, because it's possible to add stuff to a bag. I'm sure they'll call the ME. I'm sure they'll call them. If there was anything in the IV bag, that would have been in her body and on the tox report. I don't know. I don't want to get too much into the speculation as to why she did different things. But sadly, I think both for us and for the family, that these types of events just leave more questions than answers. I agree, Mickey. It's terrible. Okay. Any second now, we'll be back from our break. And we're going to continue probably with the next witness from the plaintiff. I know we've got 2 doctors for the next 2 days, but I'm not sure if they're going to start today or not. I'm getting distracted. I keep watching Judge Boyd's feed. We might have to pull that up and have it on another window here. Let's see which feed do I have available. I don't. Yeah, her birthday is November 2nd, but we're delivering them October 2nd. Betsy, let us know if you see the flowers show up, all right? She has a bunch of roses. Looks like a dozen long stem red roses, and then you've got the little orchid there in the back. Big purse, but I think she's got room for another display. Judge Boyd is Judge Stephanie Boyd. She's a judge in Bexar County, Texas, that we like watching on YouTube. And chat, you guys wanted her to get some flowers, so you sent me money for that, and I bought the flowers and ordered them for her.
One matter. Earlier today, we handed the court, and of course we prepared and sent over to the defense last night, the full exhibit list for all of the witnesses today, and we didn't get all the way through it, and when we were discussing it, I wanted to move in some of their policies and procedures. There's a number of them, but I only have 1, 2, 3, 4 to move in, and I'd like to move in 2252001, which is the risk assessment for potential child absence. Can we pull that up for the court? This won't take a second, Judge. 2252001.
Trying to raise the volume a little bit because they're away from the microphones.
All of these are policies of Johns Hopkins. And I thought they were in the Johns Hopkins records, but apparently they're separate.
This is on midnight, late night.
How many pages is 2252?
2.
And how are we going to be using this?
This witness is a social worker.
Who's the witness?
Deborah Hansen. She's a social worker, and out of all of the ones that we listed from last night, we really only have one. We have that one. We have 2214001 through 007.
Okay, let's deal with one at a time.
Yes, sir.
So 2252. And it's some sort of matrix as to when to make an abuse report?
Yes, sir.
Judge, this is going to be a recurrent theme with this witness, I'm afraid. This witness was a social worker who made the initial call to DCF on behalf at Johns Hopkins All Children's Hospital. She saw this patient and the family for about 2 hours on the day of admission. She's testified that she had about 10 to 15 minutes contact with Maya Kowalski that day, but most of her involvement with the case was making the first phone call. And this child abuse recognition matrix has nothing to do with anything that is left in the case after the rulings that have been made by the court regarding the good faith and reasonableness of the first of the phone calls in general, as well as the Chapter 39 immunity. So I don't see the relevance of 2252. A number of these policies and procedures are trying to move in right now came over yesterday evening after I had looked at the exhibits for today. I was not aware until, frankly, this morning that these additional exhibits were going to be proffered today. But that one has no relevance, number one, for this witness in particular, but in general, as to the case any longer.
Mr. Anderson, it doesn't seem like this goes to anything that's actually in the case.
Judge, yes, it does, because our case is not predicated upon those 2 calls. Our case is predicated upon, on the medical malpractice side, about them, the timing of when they made a decision on a diagnosis and whether there really was any type of team or differential diagnosis. Debbie Hansen can testify, and she is in the medical records.
County, this is an objection.
Fairly extensive reports that she put in, and she can testify to how the Kowalskis presented when they first came in, because she was there. She was on duty that day when they first came in. Whether Beata Kowalski appeared reasonable or whether she appeared to be out of control, as has been portrayed elsewhere in the records. She can testify to whether they were agreeing to stay or not to stay over the 24 hours, which is one of their big points. She can testify to how Maya ended up in the PICU so quickly, She can testify thereafter about the steps that needed to be taken, and mostly she can testify to before there was supposed to be any overarching diagnosis, especially any psychological diagnosis, how the social worker has to be involved by their own rules and regulations, and how she was told she did not need to be involved in this, and she was not going to be involved in this. And so her testimony...
So she's not involved, but she made a call to the hotline? It doesn't make any sense.
That's exactly our point. She was directed specifically by Lisa Winton to make a call to the hotline before she completed her social psychological evaluation, which according to their rules is absolutely necessary. Not, and leave aside for a second the call, but that's necessary in the evaluation of the patient. So she has very important information to get before the jury about what the practices and procedures were. She had been there since 2009. She had been there at the time Johns Hopkins took over.
Well, 2252-001 and 002 go to nothing that is in this case. So
Well, because look at other fictitious.
I'm going to sustain the objection that document's not coming in.
All right. And then
the reality is, you know, the court wrote, I guess about 2 years ago now on this, maybe a year and a half ago, about as soon as the court made the conclusion that there was, I forget the specific standard, but reasonable cause for the call, then Chapter 39 immunity applies. And I know I had some discussion about the good faith and all that, but you know, I concluded the existing case law forced me down the road that I went. And so
I understand. May I speak to that?
I'm confident on that ruling, and so I think we need to move on to the next issue.
So 22-14001, this is the mandatory requirement of a social worker being notified and involved in the event that there's any claim of medical child abuse, which there was to start with, morphing into Munchausen by
Let's put
proxy.
2214 up, please.
Okay, we'll see if this gets in.
I'm sorry, this is like rinse, wash, repeat. This is the same sort of thing, Judge.
Hang on.
Well, again, to be fair to me, I need to see these exhibits. I don't.
Understood, Judge.
I haven't lived with 10,000 documents or 100,000 documents like you all have for years and years and years.
Defense is not like this. They're saying
This is talking about making an abuse report, right?
No, that's
policy statement 1A. All
Yeah.
cases of suspected child abuse must be reported to the Florida Department of Children and Families Central Abuse Hotline.
That is true, Judge, but if you go down under C, social work services must be notified when a report is made or needs to be made to the appropriate agency. Social work services will assess the patient and family situation, coordinating the reporting process, and facilitate interviews made by the investigative agencies. I am not arguing this for the purposes of challenging. I specifically told the jury in opening we are not challenging those calls. What I am questioning here is the involvement of a social worker to complete the psychosocial analysis before a diagnosis is made, because we have the right on the medical malpractice count to challenge those initial diagnoses that were made.
Why can't you have the testimony, but why do you need this document that talks about sexual abuse and all these other things that...
Well, Judge, it's a party admission, and here's the big problem. If you recall, we brought up to the defendants and to the court when the entire record of Johns Hopkins was to be put in. We wanted to put in specific sections, if you recall. The defense objected and wanted the entire record put in. Now, that record is in evidence, and it speaks at length into this entire process. And I do believe I heard the court in some of these summary judgment orders and otherwise directing us that the underlying facts are one thing, and the underlying facts are game, and the defendants here seem to have been playing along with that or agreeing to it because they rejected our overture to just put in the stuff that was relevant material. I believe the court would remember me talking about this, the hearsay contained within, but they didn't. They pushed strenuously for the entire report in. Now it's in. Now all those facts are in front of the jury. Since all those facts are in front of the jury, I should have a chance to analyze them under their own rulings. And that's my big concern here.
But the policy statement 1A talks about making reports to the Central Abuse Hotline, which is not an issue in this case.
The reporting isn't, but the fact that I understand, but the fact that all of that is already in evidence, I should be able to explain it somewhat.
Anything else, Mr. Hunter?
No, sir.
I'm going to sustain the objection. 2214 is not coming in.
All right. So the next one simply involves clinical policy.
The judge staring at the
It
clock.
is not directed to, I'm sure there are some areas in here that,
I'm sorry. Can you have a number?
I'm sorry, 2209-001 through 008.
The judges can make a comment. It's like, look, we should not be doing this every day after each break, fighting over stuff you should have done days ago, if not weeks. Maya and Kyle are not here, and it's reasonable to assume they're not here because a lot of the testimony that we've heard today was very detailed and even showing pictures of their mother's the investigation into the mother's death.
Next page. Next. Yeah, like 2 more pages.
They haven't had a chance at this yet. We'll see on see on defense what happens.
Judge, this has to do with clinical documentation of patient conditions and diagnoses and treatment, none of which social workers make. There's no foundation for this to be admitted in connection with this witness's testimony, and it's not been shown to be relevant at any point in any of that.
It actually is under E8 there, and regardless of which witness it is, since we waived the necessity for a corporate records custodian.
Okay, I see 2209 as being relevant in this case. I mean, how you chart something. I mean, there's a fraudulent billing count here as well. So I do think 2209 is relevant. So I will admit 2209. Now, whether this witness is speak intelligently about this policy, I don't know, but 2209 will be received.
Next is 2237-001-004.
Is it 1 through 4 or just 1 and page 4?
It's 001 through 004.
This is discharging against medical advice?
Yes, sir.
Judge, the policy is relevant. I don't see the relevance of this witness.
It's 6. It is. It's 6 pages.
It's 6 pages as opposed to 4?
Yes, sir.
I think the policy on against medical advice is relevant in this case, so I will receive 2237, overrule the relevance objection. Anything else?
So for the record, the flow chart for it's 2237-005.
Didn't you just?
I just admitted 2237.
Okay, sorry. Then it's already in evidence, but just for the record, so we're clear, we are going to be referring to Joint Exhibit 1001-2032 and 101 2033 302031. These are notes. I believe they're social worker notes from the relevant time. They are in evidence. I was just doing something nice for counsel and know what I was going to use.
He doesn't need to do that once they're already in evidence.
We have those notes, it's fine.
Is there anything else that we need to address?
I don't believe so, Your Honor.
Anything from the defense?
I'm sorry?
No, you're right.
Okay. Let's bring in the jury, please.
Yes, sir.
I like him a little bit redder than gray, so we're going to go with the red one for right now, because I think he's angry anyway. All right, I think it's about even on wins and losses. Possibly defense doing a little bit better on objections today than the plaintiff. So I'd say it's close to even. As far as anger goes, though, the judge is not very happy with the plaintiff today, and is probably just fine with the defense.
Members of the jury, let me ask you a few questions. I want to confirm that while you were away, you did not discuss this case amongst yourselves. You did no investigation. You received no information. Is that correct? And since you were last with us, I want to confirm that no one approached you about this case. Is that correct? And while you were away, I want to confirm that you spent a lot of time watching the media and everything about this case.
Trick question.
Y'all are paying attention. I appreciate it. So I want to confirm that while you were away, you did not see any media coverage about this case. Is that correct? Fantastic. Mr. Anderson, your next witness, sir.
Congratulations, Dilly. That's awesome. I didn't hear who he's called.
You can raise your right hand.
Do you solemnly swear or affirm testimony about to give will be the truth, the whole truth, nothing but the truth?
Yes.
Come on, sir.
Maya has not been here so far this morning.
All right, Ms. Hanson, will you state your name for the record?
Deborah Ann Hanson.
And have you been asked to testify here because you were a social worker covering the inpatient room on October 7th, 2016?
Yes.
You remember that day?
Yes.
And you remember the day all of this started, that day?
Yes.
Before we go into those facts, the jury would like to know a little bit about you. You moved to Florida from Houston and when you were, 13?
Yes.
And why the move?
My dad was hired by Bendix to work on the lunar module for the
space shot, the moon shot?
Yes, going to the moon.
Did you subsequently go to college?
University of Florida.
And what years were you there?
71, 75.
And what did you study there?
Psychology and French.
Okay. And following that, did you have an opportunity to travel to Europe or before, after that?
After college, I went, it was 75, so there weren't many jobs because of oil. I went to France and was an au pair in Paris.
Did you get the chance to travel around Europe as part of that job?
On my free time, absolutely.
And so let's, before we finish, and I will go into the jobs in a moment, but did you ever return to University of Florida to pursue any advanced degrees?
Not University of Florida.
Where did you go?
Florida State University.
And what were you pursuing there?
Master of Social Work.
And did you achieve a Master's of Social Work?
I did.
After that, did you try any additional education towards your profession?
Yes. I was accepted to the first interdisciplinary public affairs program, PhD program at University of Central Florida. And interdisciplinary was health service administration, social work, criminal justice, and public administration.
And did you achieve a degree from there?
I was all but dissertation. I completed all the coursework and the qualitative exams, but I did not complete my dissertation.
Was that the equivalent of a PhD, or was it a PhD?
It would have been a PhD.
And you just didn't finish your dissertation?
I did not complete my dissertation.
All right.
It should only be delivered
when
once.
You first left, tell us the first job you had that involved social work, whether by that name or otherwise.
The first job was actually with a sheltered workshop in Stuart, Florida.
Okay. And what did you do there?
I can't remember actually. No, I did work with the population. They were disabled, mentally disabled, mentally developmentally disabled.
You have a very soft voice, so you're going to have to pull that microphone a little closer to you, if not.
Hot meat kettle.
For me. All right. And so then, what was your next position?
I worked at a residential facility in Titusville, Florida, as the Fran Walker, I forgot the full name, residential treatment facility for young female adjudicated dependent girls.
What were you doing with that?
I was doing some intervention and with the girls, and sometimes group work.
Were any of these girls, had they been abused?
I can't recollect exactly, but they would likely have been abused.
They were all challenged.
They were adjudicated dependent. And
all right. And what did you do after that?
I was hired in West Palm Beach as a child with the state of Florida in West Palm Beach as a child abuse case coordinator.
Now, is that the predecessor to DCF?
That is DCF.
That is DCF. And again, what part of DCF did you work for? As a case coordinator, were you
for children.
Okay. Was that were you part of a particular team, or was this
So when children are deemed, they go to court and are sheltered or placed out of the home for abuse or neglect, then they're placed on a care plan, and I was the case coordinator with a care plan to work with the families.
How important are these case plans on either side, that is the parents and DCF?
If a parent doesn't complete a care plan, we try to work with the parent to help them overcome any barriers to following the care plan. But if a parent is unable to follow through outside of the barriers, then they may lose the rights to their children. Rights are terminated.
But if they never sign the care plan, they're not obligated, are they?
Thank you, Your Honor.
Sustained.
Was there I'll come back. Okay, so how long did you do that?
I think until I was with the state of Florida, till 83, but I did child abuse as a case coordinator, I think until 80, and then I was hired as a child abuse investigator, so the first call comes in would go to an investigator who investigates child abuse. So then I was hired for that position, and within a year I was hired by the Orlando Regional District.
Again with DCF?
State of Florida, yes. At that point, it was a child protection team. They were newly formed, the child protection team. So I was one of them.
And what did you do there?
When a child was, there was suspicion of child abuse, the state of Florida, they were investigating. So the investigators would bring the children in to the child protection team for medical evaluation.
And did you do part of that?
I was part of the team that did the medical evaluation. I didn't do the medical, I did the psychosocial.
And tell the jury what psychosocial evaluation is
So
in this context.
So a psychosocial is looking at social factors, cultural factors, and social factors would be an education, employment, history of abuse in the family. It's more the social and the dynamics, family dynamics are all part of trying to understand this dynamic.
All right. And again, how long did you do that job?
I did that job from 81 to 83.
And what did you do after that?
I got married.
Okay. And then you had children?
I had children.
3 of them?
Yes, sir.
And how long were you out then, or did you then go to the PhD program after that?
I started the PhD program in 98.
Okay. And were you in it then, what, until 2001, 2002?
Yes.
All right. And so then what did you do?
I started working at, I went back to work as a social worker at Orlando Regional Medical Center.
And were you familiar with their policies and procedures while you worked there?
Not all of them, but
as they applied to you?
Yes.
All right. And was there anything in particular you did at Orlando Regional?
I worked with adults. I didn't at Orlando Regional. They had a children's hospital, but I wasn't working at that department. So I did adults, and it was facilitating discharge planning with case managers. So I was under the case management department.
All right. Is this where you were working as an intermediary between the parents and the medical system?
No, in Orlando Regional, I was working with adults. So I actually was working in the intensive care unit.
Your training, is it both as to children and adults?
Yes.
So then, I understand after that, or as part of that, you sent over, strike that. At that point, did you join All Children's Hospital in a form or fashion?
Yes, I left Orlando Regional and Orlando to go to the Gulf, to be on the beach.
Okay.
And I moved to Tierra Verde and got a job at All Children's as a grant coordinator to develop a parent-to-parent network for bone marrow transplant and cancer patients.
All right. Again, you got to speak up a little bit, but as I think I heard you, these were pediatric oncology patients, kids with cancer?
Yes, and undergoing bone marrow transplants.
And why is that difficult? Bone marrow transplants?
Bone marrow transplants are painful, as are treatment for cancer, and also there's always the risk of death.
Is it difficult for the parents?
Sorry. Absolutely.
Okay. And before we go any farther into Johns Hopkins, All Children's, where do you work now?
I work at a boarding school up in New Hampshire as a psychotherapist.
And
a counselor. Sorry, it's my title as a counselor.
And where is that?
Concord, New Hampshire.
It's either a counselor or a psychotherapist.
A year.
All right. So
thanks for the
this
kind words,
first job was setting up a network of parents, or was it a one-to-one parent system?
It's mentoring a parent who had been through the experience of bone marrow transplant or childhood cancer. I would match those parents with a parent coming into the program with a newly diagnosis or undergoing bone marrow.
Larissa, YouTube does take a cut
bone marrow
for providing the platform and storage.
When did you get your license first?
Bandwidth.
Are social workers licensed?
Not all.
Are hospital or medical social workers licensed?
Not necessarily.
What licenses are there for them?
In Florida, it's a licensed clinical social worker.
For what?
For Florida.
Okay, for Florida. And what are they in Florida?
Licensed clinical social worker is the license.
And when were you last?
2015, I believe. I
Okay.
completed all them. I took my time.
Okay. All right. So tell us about then after the parent mentoring, the bone marrow transplant program. What did you do after that?
It was a 1-year grant, and as I was completing the grant, I was asked to take the position as pediatric oncology social worker at All Children's Hospital. I declined. I didn't need to work, and I traveled.
Okay. And did there come a time that you came back to Johns Hopkins?
Yes, 2009.
And at that point, was it still All Children's?
Yes.
And what was your position there?
They offered me, they said, would you like this job, the pediatric oncology social worker position. I took it at that point in time. The person who had taken the position in 2007 left in 2009.
And so what were your duties and responsibilities? Let's take it forward to October of 2016. But generally, what were your duties and responsibilities? Strike it. Did you stay in that role up to 2016? All right. And explain a little bit about what that role at Johns Hopkins All Children's at that time entailed.
So the role is psychosocial support for children and families experiencing childhood cancer. And most parents, when they hear their child has cancer, it just immediately is my child going to die? So I spend a great deal of time working out whatever their barriers to care are, access to care, providing support for the families, working with families about grief in that area, anticipatory grief or actual loss of a child.
So were you then like a patient advocate, or was it a different job? Well,
I would certainly advocate on behalf of the parent and families and represent their voices in the multidisciplinary team. Psychosocial care and cancer care is a very important role.
And again, as part of your job, would you explain how the hospital system, the medical world works?
Sometimes, yes. It's a very complex.
Now, as part of these jobs over this time, did you have the opportunity to meet people of all different nationalities, cultures, types?
I got to meet people from different countries, different cultural backgrounds.
Okay. And Latino?
Latino, yes.
Black?
Yes.
Indian?
Yes.
And a few Asian folks?
I can't remember, honestly. Asian, Indian, but I can't remember Asian, sorry.
Okay. Eastern Europeans?
Yes.
Right. Okay. And so, had you had any experience prior to the wall falling in 88?
91,
excuse me, with any parents from Eastern Europe?
I'm not sure.
It would have been rare, but...
Before 91? Before the...
Yes.
So, at any time in my career, would I have worked with families who lived under the Eastern Bloc?
Correct.
Yes.
On more than one occasion?
Yes.
On more than one occasion before you met the Kowalskis?
At least once. I'm not...
All right. But did you make it a point then to understand different cultures, different needs?
I always try to understand. After living in Europe, I always wanted to understand other cultures. I spent a month in Greece, and it was like a third world, and it was...
Well, can you tell the jury why in this position
it was great to her.
Explaining to, for instance, doctors' symptoms or how the hospital operates, understanding a culture might help? It goes to...
She can answer.
Could you repeat the question, please?
Sure. Why is it important to understand different cultures in your role as a social worker, every place, but particularly at Johns Hopkins?
It's important to understand culture, family's culture, because that can impact the way they understand it, the symptoms, what the symptoms mean, what the cause of the symptom is, how you would treat those symptoms, the stigmas attached to different parts of the medical system. I can give an example if you'd like.
Sure. I think you had informed before about a was it Somali African, and explain why that might be relevant.
So Somali families,
This is simply a predicate to demonstrate an example of how you do their job.
Sustained as to this specific one.
Is it, I understand. And then in general, did you come across cultures where certain ideas, concepts, such as even depression, were unknown? Or not?
Families would understand what sadness, they knew sadness, but they didn't know it as depression.
And that was part of your job?
Yes.
Okay.
And they would treat it a lot differently than we would here in the United States. Or there was stigma attached to.
Okay. Now, at Johns Hopkins, did you work on the oncology floor?
Yes.
Usually? And was that a different floor than the pediatric intensive care unit?
Yes.
Was the floor above or below? Or?
Below. I was on the 7th floor.
Did social workers rotate? Did they go from floor to floor with a patient, or did they stay on the floor for whatever specialty it was?
I would stay on the oncology floor, and if a patient from the oncology floor would go to the PICU, ICU, which did happen, I would not continue my work as a social worker. I would go up and support the family, but it was then the social worker on that floor that would follow the family.
To integrate or hand off, is that right?
Yes.
Okay. But generally speaking, was the policy for the social workers to stay on their floors that they were assigned to?
Yes.
All right, so now I wanted to go through, if we could, a little bit about the patient and family rights and responsibilities. For the record, 10820002 in evidence, and through I think just 2 pages, no, 0003. If we could pull up the page after, that would be the 3rd page. Are you familiar with these?
Yes.
And
yes.
Did you have to consider these throughout the time you were interacting with different families?
Yes.
Patients? Could we have 10820003 up for the jury? Okay. I wanted to go through some of them, but it says there to expect privacy and respect while you receive your medical care. What does that include? Does that include chaperoning? Does that include what?
Objective relevance and foundation, Your Honor.
It's predicate for what's coming.
Overruled. So privacy and respect, from a social worker standpoint, the privacy, respect is you always respect the dignity of a human being.
Mm-hmm.
That's important. And privacy is related with HIPAA.
Mm-hmm. Okay. And then was it important then to be able to refuse treatment? If you look down to the next from the bottom there. We could.
So your question again?
Did you educate the parents, or I guess children at some time, that they had the right to refuse care other than as written by law?
I didn't do the education of the rights with the families. They were handed the Bill of Rights and Responsibilities once they were admitted into the hospital. That was typically I think it's a hospital representative who was part of the admission process.
So by the time they got to you, this had been gone over?
I don't know to what extent the rights and responsibilities.
They received it.
They would have received it, yes.
All right. And then it says to be given complete information and advice on financial resource. No, skip that one. I'm sorry. It's a different one.
Relevant to foundation,
I just skipped it.
Testified, it's not part of this process.
Well, it's part of what comes to her.
You can continue.
All right. And then I don't want to, the jury will have this back there, but I wanted to point to you to the far right column, at the top bullet point, to talk with another doctor or specialist at your own request or expense, or to ask for a transfer to another healthcare provider, providing it is medically acceptable and the other provider will accept your transfer. Is that right?
That's what it says, yes.
Okay.
That's their right.
All right. And from time to time, did you have parents who wanted second opinions?
Yes.
Was that unusual for a parent to want a second opinion?
No.
And did the parents have the right to reject what the hospital was saying was the right treatment for something?
Objections calls for a legal conclusion.
Sustained.
What, if anything, were you instructed in terms of a parent's right to accept or reject a treatment?
Same objection, Your Honor. And
He's
I'm going to overrule that one.
Will you ask the question again, please?
From your training, what were you told or trained about a parent's ability and right to reject a suggested treatment from Johns Hopkins?
Parent has the right to refuse treatment. They
And-
have the right to leave against medical advice if they so choose. There are consequences, but
Right. And then I had one more I wanted to go after. It's the middle one, the third from the bottom, to practice your cultural values and believe so long as they do not interfere with the well-being of others and are within the limits of hospital policy and the law.
Object to leading as well as critic.
Well, what's the specific question?
Specific question is, as part of your training and as exemplified here, were patients allowed to practice their cultural and spiritual beliefs, religion for lack of a better term?
Overruled the objection.
as long as it didn't interfere with care. But having said that, it's important to respect those beliefs and values.
But they're allowed to practice their religion in the hospital, are they not?
Leading, Your Honor.
What, if any?
So, for example, if some cultures want to use sage to clear the negative energy in a room, that would not be acceptable because it's fire and you don't have fire in the hospital. So, for example, that would not be permitted.
What about being able to practice the Christian faith in the hospital?
There was a chapel which was open to all faiths in the hospital.
And was the hospital required to, from your training, allow patients to practice their religion, if it was Christianity or Roman Catholics?
Check the relevance, inclusion, and predicate.
Overruled as to all bases.
Absolutely. There were some Muslim families that brought their prayer blankets to the hospital rooms and were able to practice their religion, and we were very considerate of their beliefs. And also, if there was only a female in the room, a male could not enter that room without a female present.
Okay. Wow. Now, I'd like to go over then, before we talk about what happened that specific day, a couple of the clinical policies that involve you. And if we could put up 2209-001 through 008. And I'm looking at here, well, first tell us what this is once it comes up here.
Clinical documentation policy.
And what does this involve?
Documentation in the medical record.
And then look at number 8 there under E, second page, E8.
DSN just sent a super sticker with 9.99.
E8?
Yeah.
Or A. I'm sorry.
A. No,
Thank
sorry.
you,
It's
DSN.
E on the second page, and you go down to 8, number 8.
Yes.
All right. Multidisciplinary notes by other clinical disciplines involved in patient care will be documented in the medical record as appropriate. Now, from your training, and we don't need to go through this whole thing, but was the purpose here to ensure that all important facts were supposed to be put down in the medical records?
Object, Your Honor. She's being asked to speculate about the purpose of the policy. She has no predicate for having it created.
Sustained.
Did you work within this clinical policy guideline during the time you were there?
Yes.
And were you trained on how it was supposed to operate?
Yes.
And through the course of your times there, if needed, was it available for you to review?
Was what available for me to review? Sorry.
The clinical policy, or would you have to go look for that?
I'd have to go look for that.
Okay. Now,
or talk to my supervisor.
The question would be, from the way you were trained in looking at this clinical documentation here, was it required that the different multidisciplinary roles put down the important facts about a patient's care?
Yes.
And in that process, tell us how you fit in.
I'm a social worker, so I would put in notes relevant to my role on the multidisciplinary team that affected the patient's care or impacted or disclosed.
Okay. I got it. Okay. And this is the minimum. If you look under the first page, which is 2209-001, and that is 1A, it says this describes the minimum clinical documentation standards for all patients receiving care throughout and within the all children's health system. Is that right?
Check deleting, Your Honor.
What does that require, the policy statement at 1A?
Objects to calls for conclusion, Your Honor.
Overruled. She can answer.
What's only the minimum? I mean, you have to have this information, and what you add to it is, there could be additional information you could add, but there's a baseline you have to have in the medical record.
All right, let's look then at what's in evidence as 2237-001 through 004, the discharge of patients against medical advice, AMA. Do you have that in front of you?
Yes, sir.
All right. Now, usually, if a parent was, what is AMA first, so that they understand?
Against medical advice.
So that means the hospital says you stay and you make a decision to go.
The hospital would recommend you stay and to complete the treatment. If you don't stay, I mean, you have the right to leave if you don't want.
All right. Okay, and it's divided up there. Usually, if a parent wanted to leave AMA, who was making the initial decision based on the team's input? Would it be a nurse, a doctor, social worker?
Objection calls for conclusion. No predicate.
Sustained.
In your experience, working within the team there, who usually would make the decision about a patient leaving AMA?
Same objection, Your Honor.
Sustained.
Now, there are two sections there I see, adult leaving AMA and minor leaving AMA. There on the first page. And I'll turn your attention to the minor leaving AMA. All right. So it says under A there that essentially the hospital will discourage the discharge of patients against medical advice because the risk of adverse patient outcomes. Is that right?
That's what it says, yes.
Okay. All right. And then if you look under A there on the next page, it would be 5A. And so if a patient wanted to leave, were they offered assistance to complete discharge plans to make sure the discharge was handled appropriately?
Attempts would definitely be made.
And this was regardless if it was AMA or not.
Form, pleading, Your Honor.
Sustained.
Was this true if a patient decided to leave AMA as well as with not AMA?
Same objection.
Overruled that one.
The hospital staff would assist the family in discharge, provide the resources they needed, and would attempt to do the same with families who are leaving AMA, as I understood.
Right.
I did not participate in the AMA process.
Okay. And then it says under 7 there, A, if you go down to 6 and 7, it says a refusal to sign an AMA from certificate of discharge had to be within the records?
That's my own.
She testified she's not part of this process.
Sustained.
Refusal to discharge instructions. Never mind. We'll go on. Okay. And at the end, it says this policy applies to all children's. And let's go to the last page here. And this is, can tell us, is this a flow chart about an adult leaving? Actually, it should be a child leaving, but we can use this one. Okay. This is on 2237-004.
Excuse me, Your Honor. Once again,
9 out of 10.
She's testified she's not part of this process.
Sustained.
This is in evidence, Judge. Can she
Sorry, hit the wrong
simply
button.
follow through with the jury what the process is?
This isn't the witness to do this with.
Are you familiar with this procedure for patients leaving AMA?
Yes.
And did you have patients leaving AMA through the course of your time at Johns Hopkins Children's Hospital?
I had families who were discussing AMA, yes.
And did you advise, based in part on this particular guideline, the procedures for leaving AMA?
I didn't discuss that I recall the procedures of leaving for AMA, but I would sit with the family to understand where they were, their perspective and reasoning for leaving AMA.
Understood. Okay. Again, may I inquire, Your Honor, on the trial exhibit 2237-004?
About an adult leaving AMA?
It should be a child, and there's, I just got the number mixed up. Hang on.
Judge, the witness has testified for a lack of predicate here. The policy does, in fact, speak for itself.
Lots and lots of objections here.
With Mr. Hunter.
All right. So, take us through the process as you know it for a child leaving AMA. And she knows it.
She's indicated she wasn't part of the process.
This is for her perspective, Your Honor.
She can talk to us about what she understood and her observations.
This means against medical advice.
Stop asking her questions about the AMA policy.
Stop asking her questions.
Okay. Describe that, not policy, but just procedures is what I'm going to ask.
Policy, procedures, whatever you want to call it.
All right. So let's turn to the day in question. And these are in evidence. So as turning to 100132, 2032, 0012-032. Okay.
Can anyone
your
understand
social
what
worker
number he
note?
says?
Yes, it is.
He's never read a number
Okay.
straight.
And did you prepare it?
Yes, I did.
All right. I'd like you to take us through with this, refreshing your recollection, if you need it, a little bit about what you found out and did at this time. And can you tell us what time this was first?
I wrote my note at 2:23
Okay. What time did you arrive there that day?
1 o'clock between, yeah.
The afternoon?
Yes.
Were the Kowalskis already there?
Yes, they were in the room.
All right. And so can you take us through then what was going on under reasons for consult referral? What did Maya come in with from what you saw?
So the reason for this note is when a patient arrives on an inpatient unit, depending upon the acuity of the case, that could be a factor. Social work is asked to do an initial screening.
Right. And what is your role in that screening?
Part of the role is to understand what's going on and understand the parents' or the child's point of view, psychosocial assessment.
All right. And what is a psychosocial assessment?
Psychosocial assessment is assessment to look at the social dynamics, barriers to care, cultural dynamics, family history, employment, school.
Telling you, getting the big picture about it.
The holistic, try to get that. Social work looks at a person in the environment. So we're looking at a lot of factors that impact family or person dynamics.
And does it say here that Maya was being treated with steroids for bronchial spasms?
That's, yes, my note does state that.
All right. And then it says, mother perceives extensive use of steroids resulted in RSD, which now affects the patient's entire body. Is that right?
Objectively, Your Honor.
This is a predicate question.
Overruled.
Is that
And
right?
so please repeat the question.
Sure. Does it say there that the mother perceived extensive use of steroids resulted in RSD, which now affects the patient's entire body?
Yes. Mother perceived that the use of steroids affected her daughter's body.
And did she say they already had a treating physician for CRPS?
Yes.
And is CRPS essentially the newer term for RSD, reflex sympathetic dystrophy?
She mentioned about Maya was seeing somebody outpatient for pain. Now, I didn't know those acronyms at the time. Those were new to me.
Okay. All right. So, but was it made clear that there was an outside physician who was managing the CRPS?
Yes.
And so there's more filling in, and you're informed about parents travel to Mexico for treatment and are considering traveling again for treatment not approved in the U.S.?
Yes.
All right. And then it says there that parents have definite ideas regarding pain management. Is that right?
Yes.
So they would have the right to reject the hospital's program under the Bill of Rights there, if they so chose.
Sustained.
What, if any, decision could the parents make if they decided they did not want to follow the pain regimen?
I'm sorry, would you ask that question again?
Sure. What, if any, steps could the parents take to not, let's ask a better question, were the parents allowed to reject a medical treatment?
Object, Your Honor. Calls for conclusion of the witness.
Sustained.
Under the patient's family rights and responsibilities, was there a section that says that the patient and parents have the right to reject a particular treatment if they so choose?
Objection, Your Honor, is misinterprets. It doesn't quote this as beyond the scope of her expertise, lack of predicate, pleading.
Sustained.
Wow. He's struggling to get this in.
What was your understanding of what a parent could do in the event that they rejected the proposed treatment? Could they, I don't know, did they have to follow it? Did they not follow it?
Parents can seek.
Objection, Your Honor. A compound question. It's still legal.
Well, I'm going to allow that question.
You can answer.
Parents and patients can seek second opinions.
Okay. And so now, tell us how the Kowalskis presented.
As I recollect, walking into the room for initial inpatient screen, which is part of the process, there was tension in the room. Parents were distressed. The healthcare team was distressed. So there was tension in the room. My role is to support and understand a family. So when I had the opportunity, I observed conversations, but when a member of the healthcare team, a nurse I think at the time, left the room, I was able to sit down and have a conversation with a family, develop rapport to understand their perspective and can start the psychosocial assessment.
Right.
And I thought our conversation went fine.
Did they seem in any way, did you perceive in any way that they were a threat to the child?
Objective to form a conclusion, Your Honor.
Overruled. She can answer that.
I perceived that they were distressed about their child who was, Maya was asleep at the time, but they were very concerned for their daughter.
Were they appropriately concerned from what you saw?
I worked in pediatric oncology. I saw distressed parents every single day. They reminded me of distressed parents who were worried about their child.
Did they seem as though they were acting appropriately for the circumstances, given your experience with parents with children having very painful diseases?
They were distressed parents, concerned for their child, and yes, that seemed appropriate.
All right. How long had they been there by the time you saw them? Do you know?
I knew they had come in through the emergency center. I don't know when they came in, but once they were inpatient, I believe I was the first social worker consulted.
And did you feel comfortable then that these parents could be worked with in order to try to alleviate the central problem?
Objection, Your Honor. Lack of predicate calls for conclusion.
Madam Court Reporter, can I have that question again, please?
Question, and did you feel comfortable then that these parents could be worked with in order to try to alleviate the central problem?
Overruled. She can answer that one.
So I'm sorry, could you repeat the question one more time?
Right. In there with the parents, did it appear to you to be the good parents that you could work with towards resolving Maya's issues?
As a social worker, I'm trained and I've had experience to work with distressed parents and develop the rapport, and I didn't see anything that indicated they were not people I could talk with and develop a rapport and ask questions, and I got answers.
Yeah. And over that period of time, did you see any indications and how long did you spend with them? 4 to 6 hours?
I was in and out, so I don't know a total. I would say a total of 2 to 3 hours.
Over that period of time, did you see any...
2 hours, sorry.
Thank you. Over that period of time, did you see any indications of what's known... Do you know what Munchausen by proxy is?
Yes.
All right. And had you had some experience with that before?
Minimal, but yes.
You understood the definitions?
Yes.
Did you see any signs or indications of Munchausen by proxy with this family when you went in or over your time?
I saw distressed parents very concerned for their daughter. I did not see any indication of Munchausen by proxy.
And did you see anything to indicate that the patients were being unreasonable? That is, you could not come up with any solution that they would accept?
There were times that I felt the family would benefit from being de-escalated, if you would. And that's not quite the right term. Sometimes I don't articulate well, so my apologies. But they calmed. I was in our conversations, they were calm. And so I didn't see it persist.
Was the de-escalation, from your view, involving the discussions with the physicians?
I wasn't clear of what what was the all of the causes of the distress. That was part of what I was trying to understand. What's going on that they're so distressed that
Right. Okay.
that could impede collaboration and care.
Sure. Now, how far along were you with your psychosocial analysis at this point?
It wasn't complete. I hadn't done a full assessment at all.
Did you have some of it done?
Yes.
Okay. And what was your plan in terms of continuing that psychosocial report?
Well, as I recall, there were multiple conversations going on in the room, so it was difficult to continue a psychosocial with other conversations with medical providers at the time. I can't recall exactly when I left the room to go back to my unit, but I was, I'll come back and we'll sit. But there were so many discussions that a psychosocial couldn't really be completed at that time.
Understood. Now, let's turn to 1001-232. And this is the social worker note. I believe you completed it, 14:23 says 2:23 p.m.?
That was the first, yes.
Where's our second one? All right. This one, it's 2032. I believe this is the second note, is it not?
Well, actually, if you go back to the first page, there's an addendum because as I recall in reading my note, there was concern that request for a safety assessment because Maya indicated she wanted to die is what I was reported. So you'll note it on the addendum in the previous note I added.
Mm-hmm.
But I tried to do an assessment, but she was sedated, so there was no way to complete the assessment at that time.
And did the parents explain to you the context of that?
Later, in my third visit or third note.
Tell us about that.
So then I was called back to the floor for suspected child neglect, medical neglect. So that's another process for risk assessment.
I think we're into territory that is beyond the scope of the relevance of the case. Can we approach on those?
Yes.
Yes, defense is objecting quite a bit. This is very harmful testimony to their defense. It is very helpful, even though she doesn't. It's not a very easy witness for the plaintiffs to get information from. It's very damaging to the defense. So they are making a ton of objections, which indicates there may be very forceful cross-examination that makes this lady look really bad. They might try to tear her down in the eyes of the jury to weaken the value of what she's testified to on direct. But I think they're worried right here that that this may address something outside the scope of the case. Let's see. Plaintiff's explaining something right now to the judge. Judge is asking questions of the plaintiff. I think the plaintiff's happy. The defense is not. So defense is like, we're not done yet. Let's see how this goes. Morning, Tag. Good to have you here. I heard that little peep. Are we going to dismiss the jury and have an argument here, or can we go on? I think we can go on.
Please, the court. So you were still trying to complete your report, is that right?
So I'm covering, and I
Right.
have to go back to my unit. I get another call
About what time? Say there.
later in the afternoon,
Okay.
and this time it was suspicion of child abuse or neglect.
I got it. Okay. And tell us then, did you continue a interview of the patients?
Of the family, yes. And it's like a risk assessment as well as, a psychosocial. Again, part of the risk assessment is can be in the psychosocial, or the psychosocial, sorry.
And did the family explain the context of Maya saying she wanted to go to heaven?
So that's a suicide safety assessment. That's not a child abuse or neglect assessment.
All right. So what's the difference there?
So a suicide is if I work primarily with children, and if a person is identified or has been identified as having suicidal ideation, a social worker would be contacted to do a safety assessment. Is this person at risk for committing suicide?
And then what did you do from there?
So
So did you pursue in any way some ideas about why Maya would have said this?
When I came back, as I read my notes, honestly, it's hard to remember everything 7 years ago. But from my notes, I came back again to the room as there was a referral for child abuse and child neglect. So at that time, I did ask them about Maya, saying that there were reports that Maya talked about wanting to die. I'm sorry, I can't remember the exact verbiage. And so, of course, I asked.
Was it your understanding that Maya Kowalski came in with an original diagnosis of having stomach problems, constipation?
That's what I was told.
What, if anything, was your understanding about the diagnosis? Sorry, Judge. I corrected.
You already asked a different question, so.
What, if any, what was your understanding about the diagnosis that the child came in with?
Pain. And again, these acronyms were new to me. RSD and CRS, or PS, sorry.
Okay. And so from your review here, was it apparent to you that the parents were not of the type to ever abuse their child?
Calls for legal conclusions, legal.
Sustained.
What, is it true you didn't see any signs in there of, from the parents that they would be of the type that would over-medicate or take advantage
This
of
will be
their child
objected
that
to.
way?
Same objection, Judge, in the relevance.
Sustained.
All right. All right. So it says parents have, we'll continue on with what happened. Tell me what else happened that day.
At that time when I was asked to screen for child abuse and neglect, do a risk assessment.
Yes, and what I...
Hold on a second. The attorney's approach. Please don't answer.
Okay, we are going to be 300 by lunch for sure. I'm going to say this is another objection here. Defense is asked to approach to address it. They're trying to head off a direction that they're going with this testimony. I think Jack knows where this is going. I think Mr. Anderson knows where this is going if he can get there. He is struggling. He's struggling to just word his questions in a format that are acceptable in court. It's painful. It's painful to watch this. He's so many times. How many times have we made objections to the form of the question? Objections to being compound questions. Objections to these are like lawyering 101 objections. Okay, like he doesn't know how to do his job. It's not the content. It's that he doesn't know how to ask the question in a way that you're not leading the witness. Ask the question in a way that the judge can allow the witness to respond and use it based on her knowledge and expertise and experience. Anyway, yeah, it's frustrating, super frustrating. The roadmap is difficult. I'm not sure if he has one. There's so much. His style looks so scatterbrained, and it might be intentional. This might be like, next level type lawyering on his part purposefully, but it looks so much like he just is hanging on by the skin of his teeth to this case and is trying to stay ahead of this huge, massive snowball that's about to engulf him. And he's randomly like pulling out documents and, oh, how about this one? Oh, wait, that's the wrong one. Strike that. Here's a question. Oh, strike that. Let me ask a better question. It's difficult. This is his theme song right here.
Scratch all that. Oh, terrible.
Yeah. Scratch all that.
Did you have the opportunity to call Eagle's Wings?
Yes.
And what is Eagle's Wings?
It was the counseling center that the family informed me that Maya had been where she sought counseling.
So did you follow up on that?
I made a call that Friday, part of the assessment, and no one answered the phone. I don't know if it was because of the hurricane or just the nature of an organization, but they did call me on Monday. I was no longer covering the case on Monday, and when I got the call, I talked briefly. They affirmed that Maya had been a client, I believe the family even, and so I informed the case manager on PICU that the Eagles Wing had called. This is their number, and you may want to follow up.
Sharon,
and so,
welcome. Good to have you here, Sharon.
In part of the record, it alleges that the Kowalskis refused psychological evaluation. Did you confirm that Maya was having psychological evaluation already?
At that phone call, I'm no longer covering the case.
I understand.
So I passed that over to the Kathy Beatty and the case manager.
All right. So Kathy Beatty was involved by this time?
I hadn't talked with her on Monday. She wasn't there when I arrived when I went into the office.
Who was the case manager?
I believe it was Joyce Shear.
And did you explain to Joyce Shear that you had confirmed, or that they had called back confirming that the Kowalskis had already had Maya through counseling and psychological help?
I informed them that she had been a patient. I didn't know the length of time, or affirmed that she had.
But the fact that she had. So now, to the best of your knowledge, and I don't want to know what you did after it, but to the best of your knowledge, had the team informed you of any diagnosis, medical diagnosis at this point?
All I understood was interference with care.
All right, but no actual medical diagnosis of what was wrong, whether she had CRPS, didn't have CRPS?
Overruled, you can answer.
Again, in one of my visits with the family, I think it was the first one, they were talking about CRPS, which was unfamiliar with me, but they were talking, the doctor and the family were talking about transferring care to Nemours on the East Coast of Florida, who either specialized in treatment for CRPS or was familiar with the diagnosis. And so that's the only diagnosis at that time that I was aware of.
But you passed all this along to the team member, case manager. Would the case manager be part of the team?
Yes.
All right. And you passed that information along?
Not Friday. I didn't.
Later, did you?
She would have known. She's part of the healthcare team.
Would have been in your notes.
And if she would be, I don't think they are in my notes. She would have been, the case manager handles transfers and discharges.
All right. So by this point, and what time of the day are we talking about now?
Where with which conversation or what activity?
Not on Monday, but the last.
On Friday?
Yes.
And so there were many activities going on from my role on Friday. Which activity are you referencing that you're asking me to identify the time?
At the last time you talked to the Kowalskis.
So I'd assume it must have been around 3 or 4 again.
Okay. And at that time, then, did the hospital know from some source that the Kowalskis believed their daughter had CRPS?
I was in the room earlier when the parents and the physician, I can't identify the physician, talked about CRPS and transfer to Nemours.
All right. And the parents believed that the transfer to Nemours would be for CRPS care,
That
right?
was the discussion I witnessed.
What if, well, I think it's in the note. Let me check here. Were the parents from what did the parents tell you that they wanted more CRPS care for their child?
Objection here, sir.
For a statement for medical purposes. Go ahead.
Overruled.
You can answer.
They did not talk to me.
The witness says overruled.
All right.
I witnessed that conversation in the room.
All right. So you witnessed the conversation, right? All right. And did they also explain that that there was an attending physician, a Dr. Hannah, that was treating the child already?
Yes.
So at this point, the case manager knew that this was a CRPS case from the parents' point of view. Is that right?
Form leading.
Overruled. She can answer that one.
Ding, 300.
I don't know. I didn't have much conversation with the case manager that I recall, so I don't know what she knew and didn't know, but I would assume she would have known that there would have been a discussion about discharge planning, which was a transfer to Nemours. I would assume that, but I don't know.
Okay. And so then they knew that there was a attending physician treating the CRPS, to the best of your knowledge?
Sustained.
What, if anything, did you know about Dr. Hannah and his involvement?
Just that he was Maya was seeing him on an outpatient basis for treatment.
All right. And then was it discussed in front of you what that outpatient treatment was going to be?
No.
Was the treatment she was to receive at Nemours discussed in front of you?
No.
Did you read at the time any records that indicated what that would be?
No.
All right. Can you read for me the part in your record about the Nemours transfer? You have it?
I don't see it on the screen. I don't see my notes. Sorry.
Okay. One moment.
I have a blank screen.
Okay. I'm working on it.
Okay, I'm going to update the objections because we get this question about a billion times a day, but it's going to say total objections in just a minute.
1001-2031. Oh, hang on. Don't show that one. No.
Hang on.
Can't show that one.
Don't show that one. There we go. How about that? Is that
I'll
better?
withdraw on that line of questioning. So, did you ever get a chance to complete your psychosocial analysis?
No. Or the risk assessment.
And why is that important here?
To form your honor, it assumes that there wasn't one done at some point.
Judge, speaking objection, and that's not true.
Well,
Speaking objection.
both sides.
And that's
No
not true.
speaking objections. Both sides. Going to overrule the objection. She can answer.
I'm sorry. The question.
Why was the psychosocial evaluation, your evaluations, important? Are they required?
By the child abuse policy in the hospital, a risk assessment, a social worker is or a social work consult is ordered to do a risk assessment if there's suspicion of child abuse, and then coordinates that suspicion after a risk assessment, they contact the child abuse, the state of Florida Child Abuse Registry to make a report.
In terms of the...
Hold on a second.
I'll wait for the next question.
I'm going to be objecting. I'll wait for the next question.
At the time, at the end of this, did you ever learn, leave aside the child abuse, did you ever learn what the doctors actually thought Maya had? Okay. And at the time you left, had you ever completed your psychosocial analysis towards any decision in that regard?
Ask and answer, Judge.
Sustained.
I'm looking to see if this is yours. All right, let's look at 1001-2030 at the bottom of the page there. Do you have that?
No, sir. May I have water?
All right.
Okay.
So let's look at the bottom of the page there. Okay. Let's look down there. And does it say that the patient was being seen by Dr. Hanna, a pain specialist, in the outpatient setting? And that was your knowledge?
Yes.
All right. And you said, please refer to pain team and EC notes for, and what is HCT?
Healthcare team.
All right, discussion with Dr. Hanna. Do you know if there was a discussion with Dr. Hanna?
If I reference notes, I would assume there would have been a discussion with Dr. Hanna.
All right, and then it says, HC team and mother came to a compromise for care regarding pain. Medication temporarily.
Temporarily.
Does it say that? And so were the parents willing to work with the hospital about a specific treatment?
Object to form, Judge calls for conclusion.
Overruled, she can answer.
I'm sorry, ask the question again.
Okay. It says there that HCT and the mother came to a compromise for care regarding pain medication temporarily.
Then that means that the mother, parent, and the team agreed to collaborated on the pain regimen at that time.
Okay. And it says mother told HCT, and that's who again?
Healthcare team.
All right. That patient would not cooperate with blood pressure monitoring unless she has additional pain medication, as patient had awakened and was thrashing about in the bed, right?
That's what I wrote.
And so the reason that Beata Kowalski, from the best of your knowledge, wanted the cuff to be held off was because the child was in pain and it would cause her more pain.
That's my understanding.
And so did that appear unreasonable to you?
Objection.
Sustained.
So then, did the father request a manual blood pressure cuff?
That's how my note reads, and I do remember a discussion about using a manual blood pressure cuff versus a digital.
All right. And then did the mother refuse psychiatric intervention because they don't help us?
Objection to the speculation regarding state of mind.
It's in the note.
Sustained.
Does it say mother also refused psychiatric intervention as, quote, they don't help us?
Am I allowed to answer that?
I think so.
Okay. So at the time, Mom did not want a psychiatric evaluation by this hospital's psychiatrist.
But at that time, can you tell the jury that the healthcare team, or at least you, knew the child had already received that type of care at the Eagles Wings?
Counseling and a psych evaluation are two different things.
Okay. But had they had some psychological counseling by that time, to the best of your knowledge?
They had been clients at Eagles Wing.
All right. And so, I got to watch out for this. All right. And if you look at the end there, well, I can't ask about that. And were you directed?
He says, "Oh, can't ask that."
Did any nurse or doctor ask you your opinion about this family?
Not that I recall.
And if they had asked you for your opinion at that time, would you have affirmed what you found here?
Objection, Your Honor. I don't understand the question.
Sustained.
Objection.
To this point,
I don't understand the question.
Had they indicated or shown you anything to indicate that they were engaged in any type of abuse of Maya?
Objection, Your Honor. Call for conclusion.
Sustained.
What, if any, symptoms did you see of? You didn't see any symptoms of child abuse, did you?
Same objection, Your Honor.
Symptoms. Symptoms. I understand. All right. Did you complete a psychosocial form with the family?
It's an interview, so it's not, I just hopefully remember all the questions.
Got it. Okay. And did it appear to you that, strike it,
Scratch all that.
I want to ask some more, Judge, but I got to figure out how. One moment.
Hey, Judge, I need to figure out how to ask these questions. Hold, please. No, he's got a tough job here. He's trying to dance within the lines that the judge has set as the boundaries, with the motions that have been sustained, with the motion in limines that have come up before everything. He did just say the quiet part out loud. He did. See if he can get this figured out. This is tough.
Based on the rulings, no further questions.
Ooh.
Mr. Hunter, how long do you anticipate your cross to be?
About 6 hours.
Then come on down. I know it's 12. I'm just concerned about everyone's lunch.
Sorry, I share your concern most profoundly. Good morning or afternoon, whichever that is.
It's noon right now.
We haven't met, have we?
No, sir.
You did have a chance to speak with Mr. Anderson or his team before you testified here today, correct?
Yes.
Okay. And you flew down from New Hampshire to testify here today, correct?
Yes.
If I'm understanding correctly from your deposition, you had contact with this family for about a total of 2 hours in and out of the room. Is that right?
2 to 3. I'm not,
Okay. Well, if we put up the two notes you have, first 2030, we see that your last note was signed at 6:44 p.m., correct?
Yes, sir.
So that would be after your last interaction with the family.
Yes, sir.
And your first interaction was signed off, if we could put up 2032, it looks like you opened the note at 2:04 p.m., then signed it off at 2:23 p.m. Is that right?
I'm sorry. Please answer that.
I'm sorry, I'm back at 2032. It looks like you began the note at 2:04 p.m., that's 14:04, and that it was signed off at 14:23, which is 2:23 p.m., correct?
Yes, sir.
And that would have been after your first encounter was complete, right?
Yes, sir.
Okay. Now, both these notes that you have accurately reflect your interaction with this patient, correct?
To the best of my knowledge, yes,
Okay.
sir.
As far as you know. Okay. And you never spoke with Dr. Hannah yourself,
No, sir.
but your notes indicate that the healthcare team did, correct?
Yes, sir.
Okay. And when you saw, this was all the interaction you had with this case, is that right?
I was only covering for Friday, yes, sir.
Okay. You were covering for Friday.
Covering for Kathy Beatty that Friday, which was Hurricane Matthew, yes, sir.
Okay. That's
And-
why you were in the PICU at all.
That's the only reason. And on Monday morning, when I notified the case manager that Eagles Wings had called me back to confirm that Maya had been a client.
Okay.
So that they could follow up.
Okay. I'm sorry, I thought you said something, Judge.
Not say a word.
Okay. So you didn't talk to Eagles Wings until Monday, but at that point you didn't have any understanding of what exactly the services were that the family had obtained there, correct?
I called Friday
Right.
and they called me back Monday morning.
Okay. But the point is, you didn't have any understanding of what psychological services they had gotten at Eagles Wings.
I was
beyond
told,
the fact they'd been a patient there.
I don't understand your question, sorry.
Okay. Did you have any understanding from Eagles Wings what services the family had gotten there above and beyond the fact that that they were a patient there?
Counseling, that's my understanding.
Okay. And you didn't have any idea whether it was a psychologist or a social worker or who it was?
No, sir.
Okay. And you didn't know the extent of any evaluation they had gotten there?
No, sir.
Okay. Did you have any understanding of whether the patient, Maya Kowalski, had ever been seen at Tampa General Hospital?
So, no, sir. But again, in your previous question, could you ask your previous question again?
Did you have any idea what level of psychological person, counselor, was rendering service to the family at Eagles Wings?
I didn't get that information. When they called me back Monday, I was handing that information over to the case manager to follow up.
So by that point, you're off the case.
I'm off the case.
Okay. When you looked at, when you were in the room, your note indicates that, now I'm referring to 2030 now. Your note indicates that the patient had awoken and was yelling. Is that right?
That's my recollection.
Okay. And she was saying that she wanted her sedation.
That's what I heard.
And she was throwing things.
That's my recollection, yes.
Okay.
I mean, I've seen in oncology patients feeling very, chemotherapy is very painful, and I've seen similar behaviors. So.
Okay. But she was agitated, is the bottom line.
Yes.
Okay. And that was adding to some kind of confusion in the room, I'm gathering.
Yes.
Okay. And did you have any follow-up knowledge of efforts made to transfer this patient to Nemours?
From Friday? I was witnessing the conversation. I did not follow up that day what the decision was. Is that your question?
Yes, ma'am. You had no knowledge of what happened after that?
No, sir. That would be the case manager that would handle the transfer.
Okay. And on the day you were involved, you were aware that there was a call placed in Nemours, but that it was closed due to the hurricane?
Well, my understanding is that Nemours couldn't accept her that day because of the hurricane. The hospitals stay open.
Okay. But in any event, the hurricane was a problem that day.
That was a problem on the East Coast. Nemours is on the east,
So near Orlando.
eastern side of Orlando.
Right. Okay. briefly here. Now, you were aware that the team had spoken with Dr. Hanna, but you didn't know what Dr. Hanna's treatment had consisted of?
No, sir.
Okay.
That's medical.
And if we want to refer to it later, once again, your notes and your social work notes here, or your writings and your social work notes are accurate as far as you know, correct?
To the best of my knowledge, yes, sir.
Okay. I don't have anything else. Thank you.
So they didn't really attack her. They just tried to show that she didn't know very much.
Of all of the people in the healthcare team, you were the one that was supposed to have the most input on determining whether or not there were some indications of abuse. True?
Objection. Calls for conclusions irrelevant.
Sustained.
No more questions.
Members of the jury, do any of you have any questions for this witness? Okay, just write it out, sir.
We have at least one. Look at the look Mr. Anderson was giving the juror as he's writing out this question. Mr. Anderson should look at him much more kindly, because oftentimes these jurors are much better at asking questions than he appears to be. And so they're occasionally they've been on his team. Crazy stuff on that witness. She said objection. She also asked to repeat the question, to go back. I think she felt much more comfortable answering questions for the defense than she did with the plaintiff, which would indicate that, and also the way she was saying "sir," indicate a level of respect or something for the defense. This particular witness, just my call on that. She did say overruled. Yes. Let's see if we get a question. The question is, what's going on? It's a rough Monday. It was a rough start to court today, with a lot of confusion and frustration regarding exhibits. The judge is rethinking his career path right now. Epic exposure. This particular lawyer does most of his legal work outside of the courtroom. He usually settles, so this is not his brightest area, and maybe they took the case thinking they were going to get a settlement, and turns out that it ended up in trial. Yeah, it is a smaller courtroom. I think it'll be busy again tomorrow. I think we're going to see quite a few people in there tomorrow. I'm thinking a lot of the family members that are normally there are not there because of the content they covered today with earlier this morning with the detective that showed up at the scene. Whoa, 3 jurors dismissed, and Brandy says jury's starting again.
Okay, members of the jury, I'm going to be able to ask some, but not all of the questions. The question is, who was the case manager at this time? I'm not exactly sure what this time is, but...
Well, I was the case manager on the PICU when I was there Friday. It should have been Joyce, as I recall. Joyce Shear, I believe it's her name.
Okay. And then the other question I'm not going to be able to ask. Okay. Plaintiffs, do you have any follow-up?
No, Your Honor.
And
No questions, Your Honor.
Okay. Any follow-up from the jury? Okay. Let me... Members of the jury, I think your lunch is going to be a little bit longer today.
Ooh, long lunch.
Let's have you back here at 1:45 ready to go. I will try to finish everything by then, but I'll do my best. While you're away, please do not discuss this case amongst yourselves. Do not do any investigation and receive no information. And we'll see you after you have hopefully a yummy lunch.
They're definitely talking about that juror. Definitely talking about that juror. Shiraz gifted 5 memberships. Thank you very much. Those went to Larissa Gilmore, Bianca, Jennifer Smith, Karen Dietrich. I think that's all of them. 1, 2, 3, 4, and Julie F. There we go. Julie F., Larissa Gilmore, Bianca, Jennifer Smith, and Karen Dietrich.
Out of our presence, may this witness be excused?
Probably not quite yet, Judge.
Not quite yet.
She's going to come back today, or maybe in the future.
In the future.
So, Ms. Hanson, apparently you're going to be finished for today, but there's a chance that you might be asked to come back.
Rebuttal.
But from my perspective, I just need you not to talk about this case except for with the attorneys. Okay?
Okay, so
am I allowed to go home
to New Hampshire?
And then do I fly back, or do I have to stay here? And
I have no objection to that.
Sounds like the plans are okay with you going back to New Hampshire. And
thank you.
If they want to bring you back, they'll contact you. I'm sorry?
We're okay with releasing.
Oh, thank you.
Have a good day, ma'am.
Thank you, sir.
She's like, do I have to wait here for 8 weeks until you decide to call me? Yeah, she's going back to New Hampshire. The stuff about the juror, that's in Brandy's trial. They've been waiting for a verdict in this trial. Apparently, they weren't able to reach one this morning. The judge had to interview each of the
perspective. I want to before
the jurors.
We leave, I want to.
And 3 were dismissed, and then they start again tomorrow.
My thoughts on Mr. Elliott and Mr. Alton Burns' assignment to me. But are there other issues that we need to address before we leave for our lunch?
Your Honor, I want to move in limine and, if necessary, or obtain an instruction to strike as to that we had a request for admission about whether or not a pediatric neurologist had ever examined, and they admitted they never had. Yesterday in cross-examination, counsel threw in, were you aware that a pediatric neurologist reviewed the case or was involved as of the summer of 2015? That's directly opposite of an admission. So I'd ask that no more evidence be put in, because once a party answers an admission, then they're barred from.
I'm unclear, because the admission that we read was from October 2016 to January 2017, and now you're talking about a 2015 time period, which is not part of the time frame of the admission.
Let me check the admissions. I thought there was a second one.
It would seem to me that the request for admission and that question had to do with 2 different things.
I understand, Your Honor.
Anything else before?
Only, Your Honor, we would like to inquire from the plaintiff if they intend on calling tomorrow, since it's a new matter.
Tomorrow we've got Dr. Hanna in the afternoon and Dr. Kirkpatrick in the morning.
Thank you, Counsel.
And we're going to try to play, if they somehow get done early, which I can't imagine, then we would play a deposition the rest of the day.
I'm going to ask everybody to be back here at 1:30. Now, we're still going, but I'm not sure how many people want to stay to listen to me prattle on about our jury instruction issue. But for those that want to stay, great. For those that want to go for lunch, that's fine too. Just be back here at 1:30.
So the judge is going to talk about.
Do you anticipate that the prattling on will take longer than a half hour, and will the courtroom be open?
Well, the courtroom will be open so long as I'm on the bench, so yes. And my hope is I can do it in 10 to 15 minutes.
Very good.
My hope. Okay, so if anyone wants to leave, please do that now. If anyone wants to stay, just go ahead and stay.
The judge has a lot of thoughts in his head. He wants to get out for the jury instructions. So we're gonna sit here for just a second, and we're gonna cut to this one right there. Okay. So the judge has all these thoughts in his head. He's made up his mind about the jury instruction, possibly about the relating to the mother taking her own life and how the jury should address that issue. And so he's going to try to verbalize this and get it down. The court reporter is going to type it all up and then give him a copy. He's going to review it and probably edit it and then amend it. Brandy finished up early due to jury issue in the trial. We're watching here, so I'm happy to be able to watch live today. Awesome, Holly Mack. Yeah, that I tell you, love Brandy, but I don't know what she is. She's like bad luck for jurors. She's bad luck for jurors because she gets mistrials all the time, and now they've had 3 jurors excused in her trial. It's crazy. That's awesome. It's awesome. Anyway, I'd like to. It's poking a little fun, but that's awesome. Let's see. Gayle May, woohoo! You're my first channel. I will forever be a fan. Thank you very much. I appreciate that, Gayle May. Let's see. Where else were we? We had Shiraz gifted 5 memberships, and then another one after that. And I think the last one went to P. Will for real. Congratulations there. Angie Brown, thanks for the kind words. Appreciate you being here. Let's see if they're going to. We get to hear the judge prattle on, or if we're going to lunch. Apparently, we're going to lunch. Judge is just cheering up a bit now. Taco will be on its way. Just the thought of food makes him happy, I think. I am watching. I'm currently watching Judge Boyd's desk. I've got my phone going right here. Keep an eye on her live stream. I do not see the flowers arriving yet, and they're supposed to be there by noon Texas time, which gives them, a couple hours to get there. But I don't know if once they arrive, if they're going to be like at the guard station or something, at the security, and then they're going to be held and then delivered to her room, her office, and then from her office. It might be tomorrow. It might be the next day. I don't know when they're going to get to her desk. What happened to the jury member? Which one, Dodie? I explained what happened in Brandy's trial, but nothing's happened to jurors on this one. Okay, going to lunch. I think we're all going to lunch. So I think we're going to take a lunch. We'll be back at 1:30. I'll actually be back before then. I'll make a little placeholder so you guys can all hang out and chat if you would like to before we come back. But otherwise, we'll excuse you so you can get some food and do what you need to do. I'm very hesitant to comment on the judge's hair because I know that in just a few years, I'm sure I'll be in this same position. So I'm enjoying what I have right now. And know that at some point I will look at the judge and be jealous of what he has. Let's see. Robert McNamara says, I just got home. Can you give you a brief summary of what happened? We just had 2 witnesses. Today we had first a lot of spicy argument this morning. So if you want to watch the lawyers lawyering and doing it very well, or actually doing it very poorly and the judge being very frustrated, go watch that this morning. That was mostly over the plaintiff failing to get their act together with what exhibits they're going to show. So that was this morning. We had then a witness from it was the detective that showed up at the scene after the Beata was found, that described that scene. No pictures were shown, at least no pictures of her were shown, the body, but yeah, it was very interesting, what they covered there. They got a lot of testimony that basically showed that she was not abusing illegal drugs or abusing legal drugs, as far as we can tell. We also got some testimony from, let's see, how many did we have? Did we have 3 or just 2? We also got testimony from a witness who was the on-call, or she was filling in for the psychiatric nurse, head psychiatric nurse at the hospital, when Maya was admitted. Let's see. All the updates on the jurors in the Rintalta case, if you want to announce those, Buffer. Mod Chat has all of them. Oh. I'm good. We haven't followed that one. It's going to confuse people. Basically, in another trial that we have not followed, they've been deliberating for a long time, several days, and now the judge just dismissed 2 main jurors and 1 alternate from that trial. And then now the jury's can go back and start over on deliberations with the remaining jurors. Yes, P. Will for real. You're in green. You're a member now. Good to have you here. It's official. Let's see. 3 jury on Brandy's channel. Yeah, that's what I just mentioned, Dodie. Don't cover that trial. We're not covering that one. Brandy's doing a great job on that one. 13th jurors, good to have you here. We're just, you got here in time just for lunch, so I hope you brought something to share. We're doing a potluck today, so everyone got the memo. It's potluck lunch, so please bring out your dishes and be generous and let people try your recipes. No, just kidding. We should do that, right? We should do a meet and greet where I'll bring the pickles and you all bring whatever else you want. We could do that. All right. Speaking of that, let's see. Let's talk about later this week. My wife, Mrs. R.A., has submitted her tentative plan for the podcast Friday night. So I think she's in. I think that's a go. So she's going to be filling in for Weather Watch for Thomas on Saturday, or excuse me, Friday Eve. Saturday Eve, which is Friday evening. So that's a go. And then other than that, we're still looking at possibly doing a thing with a few medical professionals on Friday because we won't have court then. So we'll have to get with Amber and talk about that a little bit. You guys are wanting cookbook recipes and stuff. We can go almost anywhere on the podcast because it's not relevant. Let's see. Other than that, we have just exciting news for just friends of the channel. For those that don't know, Dr. G from Dr. G Explains is almost like in the next 2 weeks, he will hit 100,000 subscribers, which is just absolutely fantastic. He's growing by leaps and bounds, and he's not just really good at what he does. He's an amazing person, great friend of the channel as well. We've had him on a few times. Need to have him on again. If for any reason you have not subscribed to his channel yet, please go over to Dr. G Explains and give him a follow. You will love it. He follows a lot of the same court cases that we do, and he provides his expert analysis of people and their body language and just sort of the behind the scenes. He's one of the experts that gets called on to testify in court. So it's exciting to watch what he does. Holly Mack, thank you very much for that as well. Let's see, and then Brandy, of course, you need to subscribe to Brandy as well. That's also a requirement. There's the link for Dr. G Explains. That's his YouTube channel. I've heard he has a Twitter account that has been like he built it and then didn't do anything with it. We need to sort of show him some love over there. If you like Twitter and like Dr. G, you need to go over there and subscribe over there. I believe his channel is the same, Dr. G Explains on Twitter. So search that up and give him a follow and welcome him to that platform. Okay, I think that's all. We're going to go ahead and go to lunch. We'll be back here shortly. Let's see. They said 1:30, so we'll be back by 1:15 at the latest. Let's see. Juror does another stream on trials. 13th juror. Yes, Brandy Churchwell is amazing. You will not be let down. Her ability to analyze complex data, to put it together in a way you can understand both visually and intellectually. She's fantastic. She's amazing. She does a great job. She is the chart lady. She is Brandy Churchwell, the chart lady. Love her. Good communicator. Dr. G is also a good communicator. Yes, wonderful. But Brandy has Lucy. Lucy's a cute little dog, and she has the best front porch of anyone anywhere. If you haven't watched a sunset stream with Brandy, you're missing out. Thanks for all those that are following Dr. G and Brandy, everybody else. We love when you support other amazing creators on the internet, and there are so many of them. We appreciate all of you. The internet is big enough for all of us, and we like to be a part of everyone else's channel as we all grow and learn together. So thank you very much. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again in about 45 minutes, y'all. 45 minutes is all you get. We'll see you then. Bye. Hang on. Did Judge Boyd just get her flowers? Don't go anywhere. Where are the flowers?
Because he's the guy.
They're there. Oh my goodness. These are the ones, guys. They're here. They're here. Hang on. Give me a second. This is the bouquet. 1 second. We're going to pull this up. Okay. Sorry for anyone who left already.
For the trees.
We've got to go find Judge Boyd's flowers and see. You were going to watch this. Let's see. Here we go. Hang on. We're going to get there. We'll rewind too. Okay, let's go live right here. Sorry. This is great. We're going to go back just a wee bit. Oh, they're up there on there. We're going to back up to right here. Oh, they're already up there right then. Come on, what's the time? We're going to skip through just, they're the flowers. There are flowers right there in back. And she's saying some nice things. Okay, here we go. We're going to listen to her right now.
Have you all conferred or no?
We're talking, Judge.
Oh, just have a seat.
Here we go.
Just approach when you all are ready, counsel.
Okay, watch the door back there. Watch the door. See the dude comes in right there? That's him. He's carrying the bouquet. He's wearing Levi's and like a checkered shirt and a hat. But, it's okay. He's got flowers. So he passes them up through the attorneys. The judge hasn't noticed yet. Oh, now she sees them. Nope, she doesn't. She's looking the other way. Boom. That's her first look. She's like, what is this? What?
Oh. Aw. That is so beautiful.
The vase doesn't look purple right there. Okay, now hang on. The vase doesn't look purple, but that's our arrangement.
No, it's not. My birthday is not until November 2nd. Yeah, I'm like, awesome. I tell people November 2nd is the Day of the Dead. So I guess I walk in the land of the living and the land of the dead. Oh, that is so nice.
That's you guys.
Look, Monday is so beautiful, right?
We just single-handedly got somebody.
And we're having our book club today.
We got somebody with some extra special treatment from
and
the judge.
It's Daniel's birthday. Well, I believe in celebrating the entire month. Yes.
That's awesome. Happy birthday a month in advance to the judge, and thank you all of you that made the.
So he's now 21.
The
I don't
flower
know.
arrangement possible. I don't know if she's going to say anything else, but we're
31.
going to go to lunch so we can. Get some
when
food.
you're 29 and you tell people you're 29, nobody ever believes it. They're like, "Oh, you're just putting off 30."
The judge is great. All right,
I've stopped counting. Vashon, I determine my birthday by what season it is. Since I'm in the twilight of my life, I'm in the winter months. Are we going to have any cold weather this year?
Anyway, we're gonna bail on Judge Boyd.
Think so? You think it's going to be 90 degrees always?
Okay, there we go.
Well, then my.
All right. So anyway, it's time for lunch. Probably as a Coach bag, M. Young. She has very nice purses. Very nice purses. Thank you all for making that possible. I appreciate you. The vase is not as purple as I'd hoped. It does have a little tint to it, but it's not quite as purple as it looked in the picture when we ordered it. But anyway, thank you. Have a great lunch. We'll see you after. Bye-bye.